Back on the record in the Simpson matter. Mr. Simpson is again present before the court with his counsel. Mr. Shapiro, Mr. Cochran, Mr. Scheck, Mr. Neufeld, Mr. Blazier, people represented by Ms. Clark, Mr. Darden, and Ms. Kahn. The jury is not present. Counsel, what are the matters we need to take up before we bring the jury down?
Morning, Your Honor.
Morning, Mr. Blazier.
Very briefly, Ms. Clark and I have talked about Dr. Reeder's testimony. As you might recall, Dr. Reeder's was in the middle of cross-examination when he had to leave.
I recollect.
And we then called Agent Martz. I want to ask Dr. Reeder's questions about Agent Martz's testimony. He has reviewed it. I've told Ms. Clark that I have no objections if she just wants to start crossing him on that, so we don't need to stop and recall him and that sort of thing. So if that's agreeable with Ms. Clark, that's fine with me.
Yes, I've informed Mr. Blazier that'd be fine, that I'm not going to go through the rigmarole of having him leave and come back or walk out the door and come back when he's recalled. That's fine. I'm not going to be able to completely cross-examine him on what he would be saying about Agent Martz because I really don't know until I hear the direct, so I'll have to reserve some of that for cross, but I'm going to make this as expeditious as possible. So.
All right. Anything else we need to take up? Mr. Cochran?
We'll have some things to talk about probably this afternoon, so we'll get this going this afternoon.
Okay, I had anticipated this morning because I didn't bring the jury down.
Oh, the jury is. Oh, do we have a vote there? Okay, thank you. Your Honor, a couple of things we'd like to address, if we might. One, regarding the tapes, Your Honor. As the court can imagine, we've all been quite busy. I understand the prosecution now has the tapes also. And one of the things I wanted to address was that with regard...
Do they have the tapes and the transcript?
I don't know. I was just advised by Messrs. Schwartz and Regwan that they were going to get, I presume, the tapes and the transcript
Ms. Clark indicates that they have both.
Right. And he called and indicated while I was back east this weekend. Your Honor, with regard to that, I would ask, with regard to the people who can listen to the tape, we've obviously got to expand it from the defense standpoint because Mr. Bailey is handling Detective Furman. And we certainly anticipate that he's in the middle of cross-examination, so it's kind of unfair that he can't, he has to know what's on these tapes. And so we've got to extend it further. Because these tapes are so voluminous and there's so much information on these tapes that I believe this court is going to find very, very relevant. We need Mr. Dershowitz and Professor Dershowitz and Professor Ullman also involved because we anticipate any motion they may bring. Clearly, they're relevant. And the question is, we don't want to play at this point 13 or 14 hours of tapes. Maybe 5 or 6 hours, but certainly not 13 or 14. But we'd like to narrow it down. In order to do that, if the court pleases, we want to be able to share that with our colleagues, and we want to do a major brief spelling out the various points and the various relevance. And I think it'll be helpful to the court. We're going to have a copy for you. Well, I should back up and say this. Ms. McKinney's in town, and I had asked her, if you remember last week, to bring the original for this court. And I will, hopefully tomorrow, we can have you the original and a copy of her transcript. And then, as I indicated, my office is doing a separate transcript which we can compare. And but you need to read these transcripts, and it's a lot of work, but you need to hear this for a lot of reasons. And so that's what I'd like to do. And certainly, specifically, Mr. Bailey isn't here this morning, but certainly he has to be part of it because he's going to be.
I agree with you that since Mr. Bailey is the individual conducting the examination of that particular witness, that he ought to be included. Something perhaps we should have thought about when the protective order was originally.
Right.
But the thing is, the protective order was submitted by counsel for Ms. McKinney, Mr. Schwartz, and Mr. Rigwan. So
Yes.
it will need their acquiescence.
Well, it will, and there'll be no problem. I spoke to them from back east, and the other matter that we talked about in the 1054.7, they've acquiesced, they've been in touch, and they will be, they've allowed that also. And so I'll ask them to send you a letter today.
All right, if you'll secure for me then their consent to that, with the understanding no copies be made by any of those three counsel, Mr. Bailey, Mr. Dershowitz, or Mr. Ullman.
Certainly. And are there any limits on the prosecution, Your Honor?
The defense, they have not, Ms. McKinney's counsel have not asked for restrictions on the prosecution.
No, no, that was my understanding. My understanding was they wanted to protect the proprietary rights
I'm
of
sorry.
these tapes.
No, I
It
stand
had nothing to
corrected.
do with the
Stand
whether-
corrected. The protective order did include the prosecution.
All right. The problem with what you just said, and I'd like to just clear this up. Dershowitz is, as the court knows, in Massachusetts, so it's very difficult. We can't work with one copy where he's concerned. So I will address that as soon as I can reach Messrs. Regwan and Schwartz, because obviously we got to send a separate copy to them and they've already acquiesced to a separate copy to others as it is. So we expect that we can handle this if the court pleases. The other matters, Your Honor, Professor Ullman will be here this afternoon, and we'll be talking about the Kessler, Bosco, Savage matters. And I think that Mr. Scheck would like to address the court on the whole idea of the jury view and it's our position it's unnecessary and too costly, but I'd like Mr. Scheck to do that at this point if the court pleases.
All right. Well, here the problem, Mr. Scheck, though, is that the individuals from the district attorney's office who were present aren't here. Why don't you put it in writing, put your objections in writing? Okay. All right. All right, the record should reflect that on Sunday evening at 8 o'clock, the court met with Mr. Scheck and Mr. Douglas and Mr. Yokelson and Mr. Hodgman, and the five of us went to the Bundy and Rockingham locations in the evening hours to view Bundy and Rockingham for the purposes of determining whether or not a nighttime viewing would be appropriate in this case. And I'll take up any objections or suggestions from counsel in writing, but we should resolve this issue by Wednesday. All right, anything else before we bring the jury down?
Yes, Your Honor, I think we should approach that
On what issue?
on the tapes issue.
We're not going to discuss the content of the tapes, are we?
No,
I mean, is there anything we can't discuss here in open court?
yes, it is something that we can't discuss here.
Why is that?
Yeah, I really. I think we should address this at sidebar.
All right, with the court reporter, please. And Deputy Jackson, would you make arrangements to have the jury brought down? Simpson matter, all parties are again present. Jury is not present. Record should reflect we've had an in-chambers conference on the record regarding the alleged tapes and the well, at this point I haven't seen them yet, so in my mind they're still alleged. All right, thank you, Mr. Shapiro. And also the conflict issue that's raised has been raised by counsel. All right, anything else that we need to discuss before we continue with Dr. Readers?
You want to put it, may I have a second here? with regard to this whole matter of the affirmative tapes, and I can tell you they do in fact exist, we will also be preparing, as the proponent of the evidence, a brief for the court, setting forth those things that we think are very relevant, and there are numerous, but we understand the areas that the court has previously indicated would be relevant. There's one other thing, Judge. There's this overall category of credibility, where a witness may have said something on the stand which we can now disprove. But there's also something else these tapes bring to mind, and that is this particular officer's entire personnel record and what's in it, or what should have been in it, and what this court may not have seen, based upon the numerous incidents he talks about of physical violence and force he's been involved in. And so we have a number of things to go back and look at. And then finally, you'll recall that when this particular officer tried to get off the LAPD and told about all of his violent proclivities and his racist views, that was discounted by the LAPD, who basically said, well, we don't believe you're a racist, we believe you're a liar, go back to work. And the point then becomes, some of those things may now be very relevant by what we now learn out of his own mouth. So there's a number of issues that we want to kind of focus on and then get back to the court on as we resolve these and move ahead as quickly as possible.
All right, I realize that there's a large circle of items that are potentially included here.
All right, thank you.
All right. All right, let's have the jury, please.
You asked us to put something in writing. Will the court allow some argument on that also?
Absolutely.
All rise.
All right, let the record reflect that we've been rejoined by all the members of our jury panel. Good morning, ladies and gentlemen. My apologies to you for the late start this morning. However, I've been meeting with the lawyers in chambers to discuss some issues that may be coming up that I have to deal with, and to advise you that there may be some other delays later this week, as I have some other issues I need to deal with. All right, we have Dr. Frederick Reeders back with us. Good morning, Dr. Reeders.
Good morning, Your Honor.
All right, would you take the witness stand, please? All right, the record should reflect that Dr. Frederick Reeders is again on the witness stand. And ladies and gentlemen, if you recollect, on July the 24th, Dr. Reeders presented his direct testimony under questioning by Mr. Blazier. And on July the 25th, we started the cross-examination by Ms. Clark. And because of Dr. Reeders' other commitments, he had to interrupt his cross-examination, completion of his testimony, and we are going to conclude his testimony this morning. Having said that, good morning, Dr. Reeders.
Good morning, Your Honor.
Doctor, you're reminded, sir, you were still under oath, and Ms. Clark, you may continue with your cross-examination.
Thank you, Your Honor. Good morning, ladies and gentlemen. Good morning, Dr. Reeders. When we left off on your testimony on July 24th, sir, we were talking about the sconce case, a case in which the victim they were attempting to determine whether or not the victim died of natural causes or of oleander poisoning. Do you recall when we were discussing that, sir?
I wasn't trying to determine whether he died of natural causes. I was trying to determine
Sir,
whether
could you
there-
please listen to my question of the objection motion to strike as non-responsive?
All right. Stricken. Juries to disregard. Ask the question again.
Do you recall that we were discussing that topic when you last testified on July 24th, sir?
That's not the way I recall it.
Prior testimony.
All right. He's indicated that's not how he recalls it. Next question.
Do you recall that you were asked to test some tissues to determine whether or not the victim died of oleander poisoning in the case of People versus Sconce back in 1988?
That's not the way I recall it.
What do you recall?
I recall that Dr. Baselt asked me to corroborate or negate analyses which he had done for a coroner to determine whether or not oleander constituents were present in tissues.
And what was the point of doing that?
For the authorities to decide whether or not this was a natural death or not,
All right, and that's precisely
or
what
to
I...
help them to decide.
All right, and the reason that you were asked to do that, sir, is to provide scientific evidence that would indicate whether or not the victim had died of oleander poisoning or of natural causes. Isn't that true?
That was the apparent intention of the DA, yes.
And so you did perform those tests on tissues back in 1988, correct?
I performed the analysis in 1988, that's correct.
And you performed the analysis on tissues that were recovered from the 1985 autopsy, correct?
That had been in the freezer since 1985, right?
Is it your testimony, sir, that it had been in a freezer since the time that those tissues were taken in autopsy in 1985?
That's what Dr. Lovell told me, yes.
Sir, do you recall performing some of your testing on the fixing fluid known as formalin?
Yes,
And that fixing fluid is used to preserve tissues that are refrigerated and not frozen. Isn't that correct?
that fluid is used on tissues which may not even be refrigerated, which are kept in a glass jar in storage for making sections. But the tissues that Dr. Lovell sent me, or rather that Dr. Basil sent me, because I got them from Dr. Basil, according to him and Dr. Lovell, had been kept frozen.
And they were kept frozen in a fixing solution called formalin?
No.
Then why were you testing formalin for the presence of oleandrin?
I think that that was in addition to tissues. I don't remember why, but the formalin that I received evidently had been in contact with the tissues because I believe it turned out to have oleandrin in it. I'm not sure about that. It's one of the pieces that goes with the case. That's all I recall, can tell you.
What would be the purpose of having formalin? Why would you have formalin if the tissues were frozen?
52 grounds.
Because the formalin would reflect the environment of tissues that were kept in formalin, I assume, or else the formalin was material used for embalming the body. I don't recall. Either one happens all the time, that with old cases one gets a sample of formalin, either from tissues, from wet tissues as they call it, or from the embalming fluid.
Is it your testimony, sir, that they put tissues taken from a victim at autopsy into formalin and freeze it in the formalin?
No, I didn't say that.
All right, so if you had formalin fluid
Excuse me, I made it very clear before that the tissues that are put in formalin are usually kept on a shelf, not even refrigerated.
Then the fact that you tested formalin fluid from the tissues taken from the victim in the sconce case would indicate that they were not frozen right away, wouldn't it?
It doesn't indicate anything except that I got some formalin, which could have been embalming fluid, or it could have been formalin in which tissues were fixed.
Nevertheless, you did test the tissues and the formalin that was recovered from the 1985 autopsy, correct?
Let's refresh my memory.
And exactly what is it you're trying to refresh your memory about at this time, sir?
Whether or not I tested formalin.
And the file that you're looking through, sir, is that your file from the sconce case?
Yes. What's left of it?
You don't have the entire file there?
No, here, no.
Where do you have the entire file, sir?
The entire file or the rest of all kinds of extraneous things in addition is in the hands of Mr. Blaze.
Mr. Blazier?
Yes.
And when did you give Mr. Blazier this file, sir?
When I got here,
Sustain.
Your Honor, I'd like to...
This is far afield about formalin and whether or not it was tested.
I'll withdraw the question, Dr. Reeders, about formalin.
All right,
Yes.
next question.
I analyzed it as fixing fluid. That's what it was.
Okay, and that's formalin, isn't it, sir? Fixing fluid?
In this case, yes, there are fixing fluid.
Okay. So you did analyze that in this case? And that would tend to indicate to you... Never mind, strike that. When you got the tissues, sir, were they frozen?
Yes.
And did-
the tissues I got as homogenates and as blood, they were frozen. They were
Okay.
shipped to me frozen right off the vessel.
And you maintained them in a frozen condition, did you?
Yes.
And then you...
Just for sampling.
All right, and you performed 3 tests, correct? The radioimmunoassay, fluorescence spectrometry, and thin layer chromatography, correct?
Fluorescent spectrophotometer. Yes. And it's high performance thin layer chromatography, which is limited.
All right.
All right, Dr.
Now, those tests-
Hold on, why don't you swing the microphone?
Oh, sorry.
Now, those tests were the state of the art back in the 60s, weren't they?
60s?
Yep, 60s.
Cool. What's the relevance of the 60s? This is test done in the late 80s.
I know, Your Honor.
Proceed.
And
No, proceed.
that's the point.
Proceed.
Actually, in the
Wait,
60s,
wait,
I'm sorry.
wait. Proceed.
Do you recall, when you began practicing as a toxicologist, that was in the 50s, is that correct, sir?
In the 40s.
In the 40s. And in the 60s, what was the state of the art testing?
Sustain.
All right, when you performed those tests, the result you got was positive for the presence of oleandrin, correct?
Yes. And oleandrogenin.
And oleandrogenin. All right, now the presence of oleandrogenin is an important fact, is it not, sir?
In the identification, yes.
And that's important because when you have decayed or decomposed tissue, the substance oleandrin may break down into a metabolite, in this case oleandrogenin, so that even if you don't have oleandrin, if you have oleandrogenin, you can still substantiate that it was present. Isn't that right, sir?
No, ma'am, it's not right, if I may correct you.
Well, if it's not right, sir, then let me ask you another question.
Well, let me explain, if I may.
Wait, no, hold on. He can answer the question. Answer the question, doctor. Go ahead.
I said, no, that is incorrect. May I explain what is correct? Oleandrogenin is formed in the body as well when you take it, when you take oleandrin into the body. It is also formed in the plant itself, in the oleander plant itself. It also is formed if oleandrin starts to break down for any other reason. So in this particular case, the issue was not whether this was a decomposed tissue, but whether or not there were compounds present which would give a pattern, which is more important than just a single compound, that is consistent with and therefore corroborative of having originated in oleander constituents. That's what the oleandrogenin means in this case, that on the thin layer chromatography, that plus some other metabolites or breakdown products of oleandrin were found, giving a pattern which gives a high degree of identifiability to the compound, because you have a whole pattern rather than just one little streak.
Right, next.
So then the finding of oleandrogenin was an important corroborative tool for you to determine that, in fact, it was oleandrin that you saw.
352.
It was one of them, yes, of course.
Do you have the report that you submitted on the case concerning your findings?
All I have is the handwritten report. I don't have any of the typed copies. Or a copy of the handwritten report, I should say.
All right, Doctor, I'm going to show you the report that you actually, typed report that you wrote, that you did back in the Scott's case. A copy to counsel. I'm going to show you a copy as well, Doctor, and I'm going to ask you to point out where, in this report, you determined that you found oleandrogenin.
It's not in the report.
It's
But
not
it's
in the
it's in my notes.
It's not in the formal report, Doctor?
No, it is.
Sustained. Rephrase the question.
You acknowledge that's an important finding, the oleandrogenin, yet you did not put that in your report.
It wasn't important to the report. It was important to my conclusion of the report to have enough factors to call this with reasonable certainty the presence of oleander.
And let me ask you then, Doctor, why was it not important to put in a report when you just acknowledged that the constituents of oleandrin were an important corroborative tool?
Sustained. Rephrase the question.
You did not put that into your report to Dr. Lovell?
Overruled.
Is that right?
Is what right?
You did not include the finding of oleandrogenin in your report to Dr. Lovell. Is that correct, sir?
Hold a moment. That is correct.
Now, Dr. Lovell, he was a coroner back then. Is that correct?
That's correct. Pathologist. And
Pathologist. And he had signed off on the report back in 1985 in which his medical examiner, Dr. Holloway, determined that the victim died of natural causes, actually from a fatty liver disease, correct?
I don't have any of that information.
Doctor,
Indicate he has no other information.
did you read the autopsy report created by Dr. Holloway back in 1985?
I don't recall, and I don't have a copy of it.
You don't recall? Did you remember testifying in the sconce preliminary hearing, do you not?
Yes, I remember testifying in it.
And you recall testifying that you had in fact read that autopsy report?
I don't recall it, but if the transcript says so, then I did. I'm telling you, I don't recall.
Would it refresh your memory, sir, if I were to show you a page from that preliminary hearing in which you
Possibly.
acknowledge that you read the autopsy report?
Well, I don't deny that I read it. I don't recall that I read it, and I don't have a copy now of the autopsy report. That's all I told you.
Well, then let me show you a copy of the autopsy report, sir.
Sustained. It's irrelevant.
May I be heard, Your Honor?
Nope.
Were you aware at the time that you did your testing, sir, that there had already been an autopsy report prepared in which it was written that the victim died of natural causes?
Foundation irrelevant.
Sustained.
Sir, when you testified at the preliminary hearing, you recall testifying that there had been an initial determination that the victim died of natural causes based on the autopsy report, correct?
Counsel, I don't know what the relevance is of this because we've already established the reason he was doing this testing was to determine whether or not this person died as a result of oleander poisoning, not natural causes. So the jury already knows that. That was the purpose of this testing. So let's move on.
Goes to the nature of the report, Your Honor.
The report is not real relevant.
All right, Dr. Reeders, nevertheless, you acknowledge you did not put the finding of oleandrogenin into your report.
Sustained.
All right. You did put it, however, in your notes. Is that what your testimony is?
It was part of the thin layer observation, important part of it, just like in the paper that we wrote.
Can you show me the notes that you're referring to?
Well, maybe. No, it's not in the run sheets and the thin layer results, or the thin layer laboratory notes on it. None of the lab notes.
All right, Doctor, why don't you swing the microphone over?
So you have nothing in the notes now before you that indicate that you found oleandrogenin.
That's what I said, yes.
And in your testimony at the sconce preliminary
I have
hearing,
nothing in my notes of what of the actual description of the thin layer plate.
you recall testifying at the preliminary hearing in the sconce case, sir, you never mentioned the finding of oleandrogenin, did you?
I don't recall. I may not have.
And if we take time over the break and I let you review the testimony that you have in the sconce matter, you can refresh your memory as to whether or not you did, in fact, testify to that finding.
Yeah, I'm going to object and ask for
Sustained.
proof.
No. Sustained. It's irrelevant.
Okay, Dr. Reeders? Do you recall having a conversation with a man by the name of Dr. Brian Finkel in Anaheim back
Yes.
in 1990?
Yes,
And that man was a toxicologist for the defense in the sconce case, is that correct?
yes,
And you recall telling him that you found one spot on your thin layer chromatography which would indicate you only found oleandrin and not oleandrogenin.
absolutely not. I have a rather clear recollection of my conversation with Brian, and that is not what I told him.
So if he came and told us that, sir, that would be incorrect. Is that your testimony?
Objection, improper question, argument.
Overruled.
If that's what he told you, he's mistaken, or else.
All right. Now, you turned in your report indicating the finding of oleandrin, correct?
The quantitative finding of oleandrin, yes.
And after that, you testified at a preliminary hearing in October of 1990 concerning your finding, and that was concerning your finding of oleandrin in the body of the victim, correct?
That's correct.
And shortly after that, the defense and the prosecution agreed to do retesting. Do you recall that?
I don't know how shortly afterward it was afterwards, yes.
Well, you testified in October of 1990. The defendant was held to answer, and the testing began in the beginning of 1991. Does that sound about right to you?
I thought it came in April of 1991. Because when we met in, I think, Anaheim, and Brian Finkel and I went over what I still had left, they hadn't done the testing yet. They hadn't contacted the testing people yet.
All right. Before they did the testing, though, the body of the victim was exhumed, correct?
It wasn't exhumed, it was lying exposed in a mausoleum. So it was pulled out of the mausoleum and re-autopsied, what was left of it, by Dr. Lovell and a Dr. Root.
Right.
And at that time, specimens were taken from that cadaver, and those are the specimens that were then forwarded for testing.
Now, Dr. Reeders, you were aware of that exhumation, well, for lack of a better term, exhumation, but you were not present, correct?
At the time, I wasn't aware of it. I certainly wasn't present.
You were or were not aware of it?
I was not. Not
When
at
did
the
you
time.
when did you become aware of the exhumation?
When Dr. Lovell called me and told me that he had done an exhumation with Dr. Root, and that they had taken specimens, and the half that Dr. Root had was going to Jack Henyon at Cornell, and the other half he was going to send to me for safekeeping.
Send to you? Exhumation tissues to you?
For safekeeping, yes.
And why would he send exhumation tissues to you, Dr. Reeders?
Ask him.
All right. Were you planning to do testing on it?
No.
So you were just supposed to keep them? Hold them?
Well, that's what he asked me to do.
Can you think of any reason why Dr. Lovell would not keep those himself at the morgue?
Objection, call speculation.
Sustained.
All right. Now, shortly after that exhumation, sir, were you informed by the DA that the testing performed by Dr. Henyon for the presence of oleandrin turned up negative?
Harvey Giss, yes, notified me.
All right. Do you recall also talking to a prosecutor by the name of Kevin DeNose?
I don't recall. The only thing I recall about DeNose is two things. One, that I was supposed to contact him prior to trial, but to wait. The other thing I recall is that he sent, through Harvey Giss, a paper to me which he asked me to review whether or not that could be a basis for questioning the results. And that was a paper that dealt with a substance that is called natriuretic, N-A-T-R-U-T-I-C hormone, which tends to cross-react with digitalis and probably oleandrin in the radioimmunoassay test. That's the only thing I recall about the notes. That's the only question that he raised.
You don't recall discussing with Mr. DeNose the reason, well, let me strike that. You don't recall Mr. DeNose calling you to ask you to give him a scientifically acceptable reason that would reconcile your positive results with Dr. Henyon's negative results?
Absolutely not. Nobody asked me to reconcile anything.
No one asked you to reconcile anything?
Nobody talked to me for practical purpose after that, as far as I recall.
Sir, I have a memo here from Mr. DeNose that I'd like to show you. Let me direct counsel to page 6. Bottom of page 6, going up through all of page 7.
All right, this is a memo from Mr. Janos to Dr. Readers.
Yes, Your Honor, I asked it to be marked next in order. No, this is to his boss, Michael Bradbury.
Check and after approach.
Wait, it's a memo from Janos to Bradbury?
Right. It's a memo from Kevin DeNose to Michael Bradbury and Harvey Giss,
All right,
in which
okay.
people's next in order.
I object and ask for approach.
All right, with the court reporter. All right, thank you, counsel. Ms. Clark, that'll be marked, that memo will be marked People's 585.
Thank you, Your Honor. Now, Dr. Reeders, is it your testimony that neither Mr. Giss nor Mr. Denos, neither of the prosecutors ever asked you to reconcile your positive findings with Dr. Henyon's findings?
That is correct. The only one who spoke to me were two people. One was Harvey Gist. The other one was the investigator from Simi Valley, Ventura County, or L.A., the chief investigator of this case, the police investigator, I believe. Those were the only two people who spoke to me, neither of which asked me to reconcile it. Quite to the contrary. If I may, I can tell you what they did. It's what I was told.
Well, we can go back to that if you want, Doctor. Right now, let's...
Entitled to finish.
Dr. Reeders, it's my question to you is only this. After Dr. Henyon's results came out, found no oleandrin,
Right.
is it your testimony that no one asked you to reconcile the difference between your finding and his? Is that your testimony?
That is absolutely the correct thing.
I'm going to show you, you have no memory of that whatsoever.
None whatever that anybody asked me to reconcile.
All right, Doctor, I would like to show you this memo written by Mr. Denos. And tell me if the representations he makes concerning statements made by you refreshes your memory and is true or false.
Ms. Clark, that's actually not a question. It's a question, does that refresh his recollection? That's the only question, not the content of the memo.
Does that refresh your recollection, sir?
Give him a chance to read it.
May I read it?
Yes.
Well, I'll let you know when I'm done reading it.
All right, let's stop that.
All right, I've finished reading it. What's your question?
Do the passages in which I've just pointed out to you that you can see bracketed here in black on pages 6 and all of page 7 refresh your memory as to a conversation you had with Mr. Denos concerning your attempt to reconcile the results between yours and Dr. Henyon's?
Not only does it not refresh my memory, but I'm reasonably certain that I did not have this conversation with Mr. Denos.
Could you have had this conversation then with someone else, Dr. Reeders?
No.
Then it is your statement here that the statements attributed to you never happened.
Sustain. It's without foundation.
My statement...
Wait,
I'm sorry.
I will sustain the objection. Next question.
May I have a moment, Your Honor? Then you offered no explanation to anyone back in 1991 to attempt to reconcile your results with Dr. Henyon's.
I don't know what you mean by I offered no statement to anyone. Of course I talked to people about it. And I pointed out that his test had nothing to do with my test. He tested pieces of fish-like and rotten meat-like leftovers from a body that had lost more than a half of its weight in decomposition taken years later than the specimens that I had tested. And to expect a positive result in a case like this is very much wishful thinking.
So it is your testimony, sir, then, that you did tell people that back in 1991 that Dr. Henyon tested only the tissues from the exhumation in 1991. and that's why he got a different result. Is that your testimony?
We both tested tissue, I'm sorry, from 1991. I don't know what else he tested. I don't see anything else in there except maybe the formalin fluid that I don't know whether he tested that, but he tested tissues that Dr. Lovell had obtained from the decomposed remains of waters. That's what he tested. It's in the report.
All right. In your opinion then, sir, is it your testimony that back in 1991, you spoke to people and you told them that the reason his negative result occurred is because he tested the older, more decayed tissues removed in 1991? Is that your testimony?
I told him what he did and what I did, and that expecting to find anything in those tissues was wishful thinking, yes. My staff I talked to about
So your answer is, sir, yes, you told people in 1991 that Dr. Henyon tested the tissues recovered from the victim at the exhumation in 1991, and that's why you got different results. Is that your testimony?
That's my recollection, yes.
And who is it that you told that to in
My
1991?
staff.
Offer here, sir.
Sustain. Sustain. Proceed.
Did you inform no one on the prosecution that that was the reason for the negative result that he got?
I didn't talk to anyone on the prosecution after that, for good reason.
And what was that good reason, Dr. Reeder?
Irrelevant.
Sustain.
Did you call Dr. Henyon in 1991 to attempt to reconcile those results?
After the analysis, no.
Now, in reviewing the document, sir, that I showed you, People's 585, nowhere in this document does it indicate an explanation that Dr. Henyon...
Sustain. Sustained. Foundation.
Doctor, would you agree that the testing of older tissue that was substantially decayed that gave a negative result for poison would be a scientifically acceptable basis to explain the discrepancy in results?
Would you repeat that, please?
Yes. Would you agree, doctor, that the explanation that Dr. Henyon tested the older, more decayed tissue would explain in a scientifically acceptable manner the reason why he got negative results and you got positive results?
Certainly.
And that explanation would reconcile the difference and allow your findings to remain valid, wouldn't it?
As valid as they were before.
Oh.
Yes.
Your Honor, I need to approach.
With the court order. Proceed.
All right, back in 1991 then, you wrote, may I ask you, sir, did you write any letter to the district attorney to explain to him what you've explained to us, the reason for the discrepancy in yours and Dr. Henyon's findings?
I don't recall that I did. I don't think so.
Then did you write any letter to Dr. Lovell back in 1991 to explain that there was a valid, acceptable scientific reason for the discrepancy in your results?
I don't recall that I did.
Did you contact Dr. Henyon?
Excuse me, hold on. Doctor, would you pull the microphone around front there, please? Thank you.
Did you contact Dr. Henyon to discuss with him the discrepancy in your results back in 1991?
1991? No, I did not.
Did you write him a letter back in 1991 to ask him to discuss with you the discrepancies in your results?
No, I think we were both on a program at the Pittsburgh conference subsequently and talked about it a little bit then, but that's the only time, I think, other than very recently, that I talked to Jack Henyon.
Now, you knew that you were to return to complete, and when was that Pittsburgh conference, sir?
I think 92, I'm not sure. We were both on the same program.
Did you have any knowledge of the status of the sconce case back in 1991?
Sustained.
Okay. All right, you knew you were to return to this court to complete your testimony today, August 14th. Is that right, sir?
Yes.
And you called Dr. Henyon on Friday, August 11th, this past Friday, did you not?
Yes.
And you called him for the purpose of discussing his findings in the sconce case. Isn't that correct?
No.
You called him to discuss what tissue he had tested in the sconce case. Isn't that correct?
No.
You called him to get him to agree that he tested the exhumed tissues and not the autopsy tissues. Isn't that correct, sir?
No.
Did you discuss with Dr. Henyon on this past Friday, August 11th, what tissues he had tested back in 1991?
It came up, yes.
And that was the first time you'd ever called Dr. Henyon. Isn't that correct?
Yes.
And you tried to get him to say that he had tested exhumed tissue and not the autopsy tissue that you tested. Isn't that correct, sir?
Objection. Form of the question's argumentative.
Sustained. Rephrase the question.
Did you tell Dr. Henyon that you believed he had tested the exhumed tissue and not the 1985 autopsy tissue that you tested?
I didn't tell him I believed that. I told him that that's what was in his report then, which I had in front of me. He didn't have his in front of him.
And he disagreed with you, didn't he, Dr. Henyon? Dr.
Yeah.
Reeders?
Well, he argued about it. He said he'd have to look it up. That's all I know.
Isn't it true, Dr. Reeders, that he told you that his notes and his memory, he recalled distinctly that he had tested 1985 autopsy tissues? Didn't he tell you that, sir?
I don't believe he told me that. I told me he thought he might have tested other tissues and he would check it out from his report, which I have here.
You don't recall him telling you that he did in fact test the autopsy tissues?
He told me he thought he might have, and he'll check his report.
Did you also ask him to sign an affidavit to the effect that he tested only the exhumed tissues and not the autopsy tissues?
No. I asked him to verify what was in his report in an affidavit, current affidavit, and to add to it also, which is in his report, that oleandrin is not a substance which is resistant to degradation by putrefaction, which he agreed. But he didn't agree to write an affidavit, but he agreed that it was, as he did in his report.
Isn't it true, Dr. Reeders, that he refused to sign the affidavit because it was not true, because he did test tissues taken from the 1985 autopsy?
Absolutely not. He said he didn't want to have anything to do with you or me or anybody else in this case. He was sick and tired of it. That's what he said.
Sir, did he tell you that he'd spoken to me?
He said he'd been pestered by the prosecution from hell to breakfast. I'm quoting him.
Is that Dr. Readers, you wanted to convince Dr. Henyon that he had tested older tissues, because if that is not the case, then the explanation you gave to this jury is wrong. Isn't that correct?
Maybe had one question at a time. I did not try to persuade him anything, and so that the second part really isn't relevant to this.
All right, let's wind up this area of inquiry.
Now, back in 1991, sir, you were made aware of the fact that Dr. Henyon used the LC mass spectrometer. You recall that?
Sure, yeah.
And in matter of fact, at the preliminary hearing, didn't the defense attorney cross-examine you as to whether or not you thought the mass spectrometer could be used to test for oleandrin?
Objection, irrelevant.
Sustained. Ask him a contemporaneous question.
I'm sorry?
Ask him a contemporaneous question. What's his opinion about whether or not that would have been a useful scientific technique at that time on those samples? Whether or not there are any advantages or disadvantages. That's the only relevance to that question.
I was just about to get to that. In your opinion, sir, when you were asked at the preliminary hearing about the use of the mass spectrometer to test for oleandrin, would that have been an effective or more effective means of testing for the presence of that poison?
I don't recall that that issue was raised, but had it been raised, I would have informed the court of the fact that that I was unaware of any published method for determining oleandrin by gas chromatography mass spectrometry. That probably a liquid chromatography mass spectrometry method might be more applicable. I'm unaware of that. I was unaware of any published method, and furthermore, I was unaware of anyone, myself, certainly in the post-mortem forensic toxicology community, who had such equipment at that time available. It was relatively rare.
And so, as a matter of fact, you did not believe that anyone had that equipment at that time.
No, I didn't say that, please. Don't put word in my mouth. I said that in the forensic post-mortem toxicology community, medical examiners' laboratories, coroners' laboratories, I don't know about the FBI, but my colleagues weren't using LCMS. The one case where LCMS was used in a post-mortem case, it was done by Hewlett-Packard out here for somebody that I knew of. So it wasn't a tool that was generally lying around available to anyone at the time. And also, what I want to emphasize is that I was unaware of any published report of an analysis for oleandrin in tissues by either GCMS or LCMS. And so I couldn't say that it could be done.
Next question. Let's wind this up. Let's try the Simpson case sometime today.
Dr. Readers, would you agree that someone who is familiar with the operation of that machine would know how to devise a test that would be effective, or perhaps would know how to devise a test that would be effective for the presence of oleandrin?
Sustained.
What effort did you make, sir, after hearing the questioning at the preliminary hearing or at any time before 1991, to determine whether the MS could be used for the testing of oleandrin?
I asked a couple of my colleagues whether they had anything available that could do the job. None of them did, and that's it.
I'm sorry, sir, what did you say?
I said, I asked some of my colleagues whether they had any such method for oleandrin available at the time, LCMS, and none of them did. That's as far as I went.
And what effort did you make to determine whether or not Dr. Henyon's method was an effective one after you learned of his negative result?
Sustained.
Did you make any effort, sir, to send your tissues, the autopsy from 1985 tissues, to Dr. Henyon for testing on the LCMS to confirm or refute the findings that you had?
That's what I proposed before the autopsy tissues were, before the exhumation was done. I proposed it first to Harvey Giss when he came up with Henyon's name. I knew Henyon, and I knew of the, by that time I found out that he had methodology available, and I offered some of the specimens that I had. I again suggested that, I think, to Brian Finkel and to Dr. Lovell, and they turned that down. They said, and I was told on the telephone,
All right,
no.
Doctor, the question was, did you offer any of the tissues?
I sure did.
All right, next question.
And you say you offered those tissues to the defense, correct?
I didn't talk to the defense. I showed them to the defense. The defense attorney, Diamond, came to see me, and I showed him. I had them wrapped tightly, sealed, signed, and everything in the deep freeze. Yeah.
All right.
And he rejected
Wait,
them.
wait. This is the end of this inquiry. It's completely irrelevant at this point. Move on to something else.
All right, Dr. Reeders, in this particular case, you did not do any testing on any of the evidence. Is that correct?
On what?
In this case, in the Simpson case,
No.
did you do any testing on any of the evidence?
No, I didn't.
You just interpreted the tests that were done by Agent Martz, correct?
That's correct.
And those tests were performed on equipment that you have never operated, correct?
Yes.
Now, with respect to the finding on the gate, you indicated that you found the single parent and single daughter ion, correct?
State's testimony.
Oh,
I'd have to refresh. I have to see what he had, whether he ran a chromatogram where he ran, whether that's the one where he ran all three or whether it was on the sock. And where, in my opinion, it showed the third daughter ion as well. I don't know
That-
whether it was this one or the other one.
All right, let me just ask you this. With respect to the single parent and single daughter ion, would you agree, sir, that there may be other compounds that are not EDTA that have that single parent and single daughter?
Possible. I don't know of any.
I'm sorry?
I said it's possible. I don't know of any. I couldn't find any either.
And isn't that also what you said in the sconce case?
Beg pardon?
Isn't that also what you said in the sconce case?
I don't know what you're talking about.
When you were asked whether it could have been another compound besides oleandrin, you said it could be, but you don't know what that would be. Isn't that right?
Probably, yeah, that's true.
I'm going to show you a copy of the report you prepared in this case. Do you have it with you, sir?
I don't know, but I do. No, I don't.
Perhaps Mr. Blazer has an extra copy. Going to mark this as People's 586?
586. Don't we already have this report marked?
I don't think so.
All right, 586.
Let me ask you a couple of questions about this report, sir. You recall that you wrote this report on July 17th, 1995, correct?
I don't recall the date. May I have a copy to refresh my memory?
Mrs. Robertson, would you make an extra copy, please?
Let me
All right.
show you the date on the. All right, you see the date, sir? And the name, Mr. Blazer?
Yes.
Let me ask you something, Dr. Reeves. You don't have a copy of your own report in this case?
Not anymore. I thought you were going to examine me on the sconce case today, so I brought the file with me.
Why don't you look at this? Does that appear to be your letterhead, sir?
Yes.
And does that appear to be the report that you wrote for your findings in this case?
Yes.
And is that dated July 17th, 1995?
Yes.
And then would that be the date that you wrote the report?
Yes.
Now, that report was an accurate summary of your findings. Is that correct, sir?
Yes.
And you received the graphs of the test done by Mr. Martz, you indicated, I think, back in March of 1995.
Sounds about right.
How many hours did you spend reviewing all those charts, sir?
Endless hours.
Can you tell us how many?
Well over 50, I know that.
You billed for your time, did you not, sir?
Some of it.
And how much time did you bill for?
I may have billed a total of 15 or 20 hours.
Out of the more than 50 that you spent? So you basically donated half your time in this case?
No. No, I didn't donate my time. I used it effectively to learn something, and so I didn't charge them for that, all right?
So how much did you bill for your work in this case, sir?
I think the total that we've built so far may be around, I don't really know. We billed $250 an hour for chargeable, forensically active work directed towards it. I think it's under $10,000.
You billed under
I
$10,000?
believe so.
And how much do you bill for each day you spend in court?
$2,500.
And so this is your second day in court, correct?
In court, actually, it's, I don't know, it's second or third day. Haven't billed any of this year.
Do you intend to?
Of course.
So when all is said and done, your billing will have been about, conservatively speaking, 15,000?
I'm sure it'll be more than that.
Do you think it'll be around 20?
I don't know. I'll bill it by time and my record. That's all I can tell you.
All right. So you spent over 50 hours reviewing Agent Martz's chart.
Yeah.
And then you wrote this report on July 17th,
Yes.
which accurately summarizes the findings of the results of your examinations of those charts and graphs, correct?
It's my opinion and not the findings. He made the findings. He
Finding.
put them in his chart. I reviewed them and came to a conclusion based on those findings, yes.
All right. And the report summarizes your opinion of his test results, correct?
Evaluation and opinion, yes, that's correct.
All right, let's look at what your report says, sir. I'm going to direct your attention, this is the first page of your report, to your opinion of the test results on the back gate stain. Specifically, sir, to Roman numeral 3. Your opinion in that paragraph is that you found one daughter ion, correct? And one parent ion that's in paragraph 2. Is that right?
No, that's not what I found. I described the one daughter ion in paragraph 3, that it corresponds to the daughter ion of the EDTA standards.
Right. And then in paragraph 2, just above it, you
Yeah.
said you found the one parent ion that corresponds to the EDTA standard, correct?
I didn't say I found anything. I said a mass spectral ion corresponding to the parent ion of the EDTA standard was present in the packet.
And that was your opinion concerning the gate stain, correct?
No, this is a description of facts that were in the packet that I got. This is not opinion. That's just a description.
Is that your opinion,
It's
sir? You looked at the graphs and this is how you interpreted them, correct?
It's not only how I interpreted them, but that is also what Roger Martz agreed to, that with me, that the retention time corresponded to the EDTA standard, that the mass spectral parent ion corresponded to the parent ion M+1 of the standard, and that the one MS ion that he monitored individually, the 160, also corresponded to that of the EDTA standard. These are things that he states in his chromatography in his report.
All right. And so this, as to this stain, we have one parent and one daughter, but not the full daughter spectrum, correct?
It says what it says. They have it in their full daughter spectrum. This doesn't refer to it.
Dr. Readers, this report, paragraphs 2 and 3,
Right.
does this show one daughter and one parent, but not the full daughter spectrum was revealed by the graphs?
I'm sorry, that's not correct. It's not in the report. I didn't refer to the full daughter spectrum because it was such a mess. But it was still there. I'd seen it.
Sir, have you reviewed the testimony you gave on direct when you were last in this courtroom?
Well, I went through the tape, yes.
Do you recall testifying that you found the full daughter spectrum on the gate stain?
I think I testified that in looking at the full daughter spectrum, that I recognize all 3 ions as showing on it, visibly.
Are you sure of that, sir?
I thought that's what I did. I don't know, as I say, I don't know whether it was the gate or the sock. Remember, I told you that. So I don't know which one it was. But on one of them, I said that.
On one of them, you recall saying that, correct?
Yeah.
Then let's assume for a moment, sir, it was the sock. Okay?
Okay, so that's the, so that would be number 2, right.
All right, then number 2. Let's go to page 2, sir. Because if according to your testimony, you found the full daughter ion, the full daughter spectrum for the sock stain, it should be revealed in your report, correct?
No,
Sustain. Answer will stand, though.
If your opinion of the results on the graphs generated by Agent Martz's testing was that the full daughter spectrum was revealed in the sock stain, would you not include that in your report?
not necessarily.
Don't you think that's an important finding, Dr. Readers?
The fact that I interpreted that as actually showing all 3 ions, I don't know whether it's important. I don't take myself that importantly, but it's a corroborative finding. Yeah.
Sir, with respect to the determination as to whether or not a compound is indeed one that you've identified to the exclusion of all others,
Oh.
is it not important, sir, to find as many identifying characteristics and reveal them as you can to substantiate your finding?
Did you say to the exclusion of all others? I never said that, did I?
Did you?
I certainly did not. It's not, nothing is to the exclusion of all others. That's nonsense. We don't know all others, all the billions of compounds.
So you cannot say then that the substance found in the rear gate and the sock is EDTA from a preserved blood tube to the exclusion of all other compounds.
To the exclusion of all others, I can say it, but I'd be lying.
Then you will not say it, will you, sir?
I'm not going to say that, no.
And
Of course
looking at
not.
your report, sir, if you will, concerning the graphs generated for the analysis of the sock stain,
Yeah. Yeah. What
that's
about
paragraph 2, correct?
the what?
Paragraph 2 of your report.
Yes.
In that paragraph, you described seeing one parent and one daughter ion, correct?
I didn't describe seeing, I described the presence, or I state the presence of a retention time, a parent ion, and a daughter ion.
You did not put anywhere in this report that you saw the full daughter spectrum as you testified on July 24th.
I have not said anything like that in this report, that's correct.
And you filed no addendum to this report to indicate that, in fact, you had found the full daughter spectrum, not just one daughter ion, correct?
Would you repeat that, please?
You filed no correction or addendum to your report to reflect the fact that actually you'd found the full daughter spectrum and not just one daughter ion, correct?
Correct.
And you would agree, would you not, sir, that the more characteristics you can find that line up with a certain compound to identify it, the better it is in terms of confirming your findings? Wouldn't you agree?
Absolutely.
And so the finding of the full daughter spectrum was an important interpretation of the graphs, was it not?
It became an important issue, yes.
But it was not one that you included in your July 17th report.
Correct.
Now, after you wrote your July 17th report, sir, you were informed that Agent Marks tested his own unpreserved blood and got the same single parent and single daughter ion result that he found in the gate and the sock stain, correct?
Similar, yes.
Not the full daughter spectrum, but the single parent and single daughter. Isn't that correct?
Yeah, he never checked the second daughter.
Sir, did you observe his testimony?
Yes.
It was his testimony that he did not find the second daughter in his own unpreserved blood. Isn't that correct?
He never looked for it.
Sir,
He
did you
said
call...
very clearly he didn't run the 132 because he didn't think it was necessary. That's the third daughter ion. So he never looked for it.
Sir, isn't it true that he testified, not just that he didn't... Isn't it true that he testified that his blood, unpreserved blood, gave the same parent and single daughter ion results that were found on the gate and the sock? Wasn't that his testimony, sir?
I think he said similar, yes. Yeah.
And didn't you agree when I cross-examined you last you were here on July 24th that the results on Agent Martha's unpreserved blood were very similar to that of the gate and the sock?
I think I said the results that he obtained and that he graphs was from the unpreserved blood. Whether it in fact was unpreserved blood, I have no way of knowing.
And when I asked you, sir, whether or not you thought he was lying about that, you said no. You had no reason to doubt that he was being honest in saying he tested his own unpreserved blood. Do you recall that?
I don't recall it, but I'd agree with it. I don't think he's lying. I think he's mistaken in one way or another.
Well, sir, so after you wrote your July 17th report, which you agree shows the single parent and single daughter ion for both the gate and the sock stain, you learned of the result of Agent Martz's own unpreserved blood test. And after that, you came in to testify on July 24th, correct?
Yeah.
And then when you took the witness stand on July 24th, you had filed no addendum changing your findings that were indicated in the report, correct?
Objection, asked and answered.
Sustained.
And when you testified, at that point only, you told this jury that you found the full daughter spectrum on the sock stain. Isn't that correct?
I didn't find it. I saw it, full daughter spectrum, yes.
You testified to your opinion that you saw the full daughter spectrum on those graphs on July 24th, correct?
No, wait. I saw the full data spectrum. It was presented to me. On it, I pointed out that you could really see all three, even though poorly, but you could see it.
That is your opinion, correct, Dr. Reeders?
I pointed it out. Obviously, it's my opinion, but I also left it for anyone else to form their opinion.
And Dr. Reeders, between the time that you testified that you testified that your interpretation and your opinion, the full daughter spectrum was found on the sock on July 24th, correct?
I think, was it the sock? I mean, it
Yes.
was one of them. That's all I know. Yeah.
But your report does not reveal that you found the full daughter spectrum on the sock, which was written on July 17th, correct?
Asked and answered.
No, I did not.
What testing, if any, did you conduct between July 17th and your testimony on July 24th?
I didn't conduct any testing at any time, as I've repeatedly told you.
And other than, did you review the graphs again between July 17th and July 24th?
Not as much in detail as I had before. I was asked things about some of them. I reviewed that. That's it.
Now, isn't it true, sir, that in order to overcome the very similar findings in Agent Martz's unpreserved blood to that of the gate and the sock stain, you decided to change your opinion concerning your interpretation of the graphs on the sock stain so that you could say that it was from preserved blood? Isn't that correct?
No, that's absolutely misleading and incorrect.
Well, sir, let me ask you this. Is there a difference in science between the term detected and identified?
Sure there is.
When you detect something, that means that it may be consistent with a compound, but isn't necessarily that particular compound that you're trying to look for.
Not necessarily. Detection can be so strong that it is at the same time a positive identification. Ordinarily, in the forensic toxicologic sequence of analysis, where what we call in forensic toxicology an forensically acceptable quantum of proof, you do two physicochemically independent tests. The first one, preferably, is one that is particularly sensitive, even at the sacrifice of specificity, and you call that a detection test. And then you do a second independent one, which is a corroboration or negation test. And so between the two, you have an identification as a basic requirement.
Then to boil it down, sir, if you have detection, you may or may not have the compound. If you have identification, you in fact have the compound.
No, you may or may not. You can't ever be sure. You go to the point of reasonable scientific certainty with the tools that you have and what you have available.
Then would you agree that there is a distinction, sir, between something that is presumptive for a certain compound and something that is identified as a certain compound? Is there a higher degree of certainty with respect to a compound that is identified than a compound that is determined to be presumptive for?
Oh.
Presumptive can be as strong as identified. Any analysis that you do for a compound, if you get a result that fails to disprove its presence, is presumptively positive. If you have several different types of tests, all of them fail to rule it out by showing could be there, then together between them, we call this reasonable certainty of identification. That's how we work that. That's the mental algorithm that's standard in this community. It means you don't prove anything, you fail to disprove. That's what you do.
Then you do not agree that there's a distinction between the terms detected and identified? Is that your testimony?
Oh.
There's an obvious difference. They are two different words, and they require, in any particular case, definition.
then Dr. Readers, would you agree that identify implies a higher degree of scientific certainty than detected?
A high degree of scientific certainty for identification, yes, but not for presence or absence.
Yes, doctor. And presence or absence means it may or may not be there, correct? It may be there, but it may not. And when you say identified, it is a higher degree of scientific certainty. Isn't that true?
It still may be in a compound or it may be something else. It can always be difference. You have failed to disprove its presence. Every time you fail to disprove, you add another quantum to having identified it. You fail to disprove. You run a series of tests. If these tests are all positive, you have failed to rule out that compound. At one point or another, you say, I've done enough tests, I'm reasonably sure that's what it is, taking everything else into consideration.
All right, doctor, would you say, let me ask you a different question. There are such things as presumptive tests, correct?
Any single test is no more than a presumptive test.
Well, then, do you see any distinction between a test that is a presumptive test and a test that is a confirmatory test?
Yeah, confirmatory is done after the presumptive.
All right. So when something is done on a presumptive test and comes up positive, you say, we have a result that is presumptive for X, whatever it is you're looking for, correct? And then when you go on and do further testing, you will confirm the presence or rule it out, correct?
Confirm it or negate it with the next test. If you do a third test, you do again the same process. It confirms the previous one or it negates the previous results.
And wouldn't you agree, doctor, that in mass spectrometry, you can only confirm a compound if you have the full daughter spectrum?
Absolutely not. It's nonsense. Whoever gave you that idea?
If people who were expert in the use of the tandem mass spectrometer said that that's what you had to do, would you disagree with them?
No, that's what they have to do. That's their opinion, but it isn't. As I said before, it's not etched in concrete. It's not from Olympus.
All right, so it's
A lot of identifications in forensic science in MSMS are done on the basis of the parent ion and a single daughter ion. It's done every day with people who have that instrumentation.
Then your opinion is, Dr. Readers, that you're entitled to create your own standard for when something should be identified or not. Is that your
No.
testimony? Is it your testimony, sir, that you feel that you can make an identification based on your own criteria?
If they are only my own criteria, then they are junk science. If they are criteria which are shared by my colleagues, then I can say yes. You know, if they've stood the test of time and of cases.
But then it's your opinion, doctor, that you set your own standards and you determine whether or not a certain standard is correct or not.
You know, I don't set the standard.
If others disagree with the standards you have set, do you change your opinion?
Just because they have a different opinion? No, one debates it, and when comes a point where there's proof that one is right, the other is wrong, then you change your mind.
But you decide when that happens, isn't that correct?
Either I or the scientific community decides. Up until the point that there's a consensus, if people have my opinion, share my opinion, then we are a group that have one opinion. Somebody else has another opinion. Doesn't mean that either one is right. Eventually, it turns out that one or the other one is right, or perhaps both are.
With whom did you consult to determine that your standard of a single parent and single daughter ion is sufficient to say that you have identified the presence of a certain compound in a mass spectrometer?
I looked in the literature, number one, on MSMS work. I have over the years many times because we've been considering getting into it.
What literature is that, doctor?
Huh?
What literature?
Scientific literature, technical literature from the ones that I looked at were from Finnegan, who makes the TSQ instrument that I think Dr. Martz used. Then Hewlett-Packard, who has put out that kind of an instrument, MSMS instrument.
And do those articles indicate that it's appropriate to identify the presence of a compound as opposed to just detect it on the presence of a single parent and single daughter ion? Is that what they say?
In some cases, yes, it is.
Could you produce those articles for us, sir?
No, I suppose I could if I went back and called them up to send me copies of them.
Could you please use the microphone, Dr. Readers? The court reporter's having a
Sorry.
hard time.
Yeah.
And if others in the scientific community disagreed and felt that the standard you have enunciated for us of a single parent and single daughter ion for the purpose of identifying a compound was inappropriate and too lax, you would simply disagree with them. Is that your testimony?
Yes, I would. I mean, they're entitled to their opinion, but it's not mine. They have no proof of that.
All right. Now, you indicated that there is a difference between presumptive and confirmed, correct?
It's a semantic difference, yes, but it's an important difference, but it is semantic. It refers to the first test, which no matter what it is, it's the first test. The second, physical-chemically independent test, then corroborates or negates, so it becomes the confirming or negating test.
Let me show you the last page of your report. Now, directing your attention, sir, to the last paragraph, which is labeled B, where you indicate, thus, the finding of EDTA in a microblood specimen, such as in the present ones, is consistent with, indicative of, and presumptive for the blood having originated from a specimen which has been placed into a usually lavender top blood collection tube, such as is commonly used to draw blood from a living person and keep it from coagulating. And the terminology you use in that paragraph, sir, is consistent with, indicative of, and presumptive for. Isn't that correct?
That's correct.
And in none of those words do you indicate the final or confirmatory language such as identified. Isn't that right?
Well, in this case, it's not a question of identified. When you talk about well, yeah, I guess so. It doesn't say identified that was it. That was EDTA blood from a tube, because you can't say that. You can only say this is EDTA blood. Presumably, because the most common source for it is a lavender top tube, it came from a lavender top tube. But it doesn't mean it did, in fact, come from that. It could come from other sources. I don't know where it came from, in short.
And the other sources it may come from, sir, well, let me ask you this. Are you aware that there are 4 different types of EDTA?
There are many more than 4, if you don't mind.
But at least 4, isn't that right?
There are more than 4. So there are 4, but there are also much more than 4.
And one is calcium disodium, isn't that right?
That's one of them, yeah.
And that's used for a food preservative, correct?
Calcium disodium EDTA is used for a lot of things, including treating lead poisoning.
Right. As well as a food preservative, isn't that right?
It's not a preservative. What it does, it ties up metals and keeps the color and flavor of food intact. It doesn't keep it from rotting.
Are you aware that it's also used as a food preservative? Did you know that?
It doesn't work as a preservative. Preservative means prevents bacterial degeneration. It doesn't do that. It's not an antibacterial compound.
If I were to show you, sir, an article, excuse me, a page out of the Merck Index, indicating that calcium disodium was in fact used as a food preservative along with the purpose of treating lead poisoning, would you change your opinion, sir?
Of course not. It's a preservative of color and flavor, but not of food as edible food. A food preservative is something which keeps food edible, and this won't do it. It'll be bacterially degraded, just as if you didn't have it in there.
All right, then it's your testimony that although it may not preserve food, it's a color retentive product
In
for the
some
food?
cases, look what it does. It ties up the metals that oxidize color and flavor. It inactivates them. That's its purpose in food.
All right, then it is used in food, though, is it not?
Yes, it is, sure.
All right. And then there's disodium only, correct?
Huh?
Disodium, I'm talking about the types of EDTA. There is also disodium, straight disodium.
Disodium EDTA is another one that's disodium dihydrogen EDTA, which when you put it into food, it usually very quickly goes to either calcium or, depending on what, mostly calcium.
All right. And then there's sodium EDTA, correct?
Yep,
And there's trisodium EDTA.
yep. There are many others, as I said.
Now, the way the anticoagulant works is that it binds up the calcium in your blood, which is a clotting agent. Is that right?
That's the anticoagulant effect, yes.
Now, do you know which form? We've just gone through 4 of the forms of EDTA. Do you know which of those can be used as a food preservative, sir?
You can use any one of them because the purpose of it is to tie up iron, copper, and a few other heavy metals which cause changes in color and changes in flavor. So you can use any one of them from a technical point of view, provided the acidity or basicity of the food is properly adjusted. Trouble is that the free EDTA isn't very water soluble. The sodium EDTA is.
Now, do you know whether these forms of EDTA were ever tested for the purpose of determining what the maximum tolerance would be in a normal, healthy person?
You mean in food, is that it? When you say maximum tolerance, how? Intravenous or in food or what?
No,
Vast
sir. I asked you
difference.
whether there was any testing that you know of that determined whether any of the forms of EDTA that we have just talked about, those 4,
Right.
was ever done to see what the normal level would be in an average healthy person.
Yes, the study of Foreman and Trujillo dealt with normal, healthy persons,
Your Honor,
and in
objection,
it they
non-responsive.
determined the.
Overruled.
Non-responsive.
Overruled.
And in this, they determined what the level in their blood was, which was in the low parts per billion below their detection limit.
All right, ladies and gentlemen, we need to take a comfort break for the jurors. We'll take 10 minutes. All right, thank you, counsel. Proceed.
Dr. Reeder, when I questioned you, when you were last here on July 24th, I asked you whether testing had been done to determine what the average level of EDTA might be in the average healthy person, and you agreed there had not been such a test. Do you recall that testimony, sir?
I recall the testimony that there had not been a population study, as one generally as ATSDR and other agencies do, that I know of.
That would determine what the average level, if there is one, of EDTA in the average healthy person, correct?
Except for the small Foreman and Trujillo sample.
I am talking, sir,
That's a sample.
I've asked you, was that test was not conducted to determine what the average level might be in a healthy person of EDTA. Isn't that correct, sir?
I don't know what it was conducted to, but it gave you that information in the small number of people.
Sir, do you recall testifying on cross-examination back on July 24th that was not the purpose of that testing back in the 1950s?
I'm sure that wasn't the purpose of the testing to determine the world population, but it was to measure the normal in those people, among other things.
Sir, do you recall testifying that with respect to that paper, they were attempting to inject EDTA for the purpose of going into studies about how it would chelate with lead poisoning and tracing it through the body? Isn't that correct?
No, that paper, that particular paper, is to study the pharmacokinetics of what the body does to EDTA. That's what the purpose of that paper was. And that includes determining that it is not detectable when you don't give it, or that after you give it, after a period of time, it disappears. It doesn't stay in the body. That's what the Foreman and Trujillo paper was, and they repeated that with some additions in a book that came out a couple of years later from a symposium.
As a matter of fact, sir, isn't it true, actually, that study found that it would pass through the body with the exception of about 5%, correct?
No, oh, no. Either you don't understand it or you're saying the wrong thing.
Objection, Your Honor. After no is non-responsive.
Yes. Next question.
Dr. Reeders, isn't it true that study made no effort to determine whether average healthy people had a certain trace amount of EDTA in their blood at any given time? Isn't that true, sir?
No, I don't think so.
You think that was the purpose of that study? Is that your testimony?
One of the purposes that the baseline was something or zero. That's what it's part of it, yes. In those people.
They took a few people and they injected them with EDTA. Isn't that correct?
Among other things, that's what they did.
What test do you know of, sir, that took average people who had not been injected with anything to determine whether some form of EDTA was present in their blood? What test can you tell us about?
That particular one, because it took zero time, that's when they hadn't been injected.
Objection, Your Honor, non-responsive.
Overruled.
What test do you know of, sir, that went out and took people off the street, took their blood, and looked to see whether there was EDTA in it? What test did that?
Told you before, I don't know of any.
Thank you, sir. Now, in this case,
Comments of counsel.
Overruled.
if a scientist is trying to prove that a substance is a particular compound, it's incumbent upon that scientist to do any test available to establish that, correct?
Would you repeat that question, please?
If, as a scientist, you are trying to prove the presence of a particular compound, wouldn't you agree, sir, that it would be incumbent upon you to do whatever tests are available and appropriate to do that?
Or else take someone else's data and review them.
All right, but then in that case, that person would have done the testing, correct?
Beg pardon?
In that case, someone else would have done the testing, correct?
Yes.
But the testing would have been done. You agree?
If it's available, yes.
And
I'd
testing?
review the testing method and the result.
And testing is the cornerstone of science, isn't it, sir?
No, the cornerstone of science is the application of the scientific method to the investigation of phenomena.
And the application of the scientific method, sir, requires that testing be done to test hypotheses and determine whether you can determine a theory is correct or incorrect. Isn't that true?
That's one of the cornerstones. The other cornerstone is to formulate hypotheses.
Okay. And once you formulate the hypotheses, you have to determine through testing whether the hypothesis is correct or incorrect.
Or you let somebody else do that.
One way or another, the hypothesis is tested. Agreed?
Again and again, yes. That's what research means.
And hypotheses may prove to be correct and they may prove to be incorrect. Wouldn't you agree, Doctor?
Well, with a genuine scientific approach, you never say that a hypothesis is correct, but you say that all tests to knock it over have failed, so it still stands until the next person comes along with a better test and perhaps knocks it over. That's why it's a hypothesis. But for the present, it has been, everybody has failed to disprove it, let's put it that way.
And theories are disproven, though, are they not?
What is?
It does occur that hypotheses are disproven by testing. Isn't that correct?
That happens all the time.
All the time. I'm sorry, was that what you said?
That's the purpose of science, is to set up hypotheses and then make tests to knock them down. And more commonly, that's successful rather than the failure to knock it down.
Now, you've been working on this case with the defense since September, October of 1994.
I have been working on these cases. I've answered various questions, and then I started working on these papers after I got them. Sure, I think September is when they first asked me some questions and asked me to look at some things.
So, were you retained by the defense in September of 1994?
September or October, I think.
And since that time, how many hours have you spent on the case total?
I have no idea. I only write it down and send it in, and then that gets billed. But I don't personally keep count of it. A lot of time, I can tell you that.
You don't personally keep count of your hours?
I don't keep them with me.
That's what he said.
Oh. You don't keep
I
them?
told you I send in the sheet with the hours, and that's it. I don't keep adding up on my fingers how many have I worked on.
Do you send the sheet to the defense? Is that it for
No,
billing?
I send the sheet to our billing department. They take care of those.
And if you could, over the lunch hour, sir, I would ask, could you have your lab fax you the billing sheet that you've submitted in this case? Could you do that, sir?
I can call up and ask them to send you a copy of the billing. Yeah. Although I think probably they have it right here.
Okay, well, we'll determine that, sir. Could you
Beg your
also
pardon?
ask we'll determine that. I'll
All right.
speak with the defense. Could you also, sir, ask that your lab fax you those articles, the manufacturer's articles that you refer to, Hewlett-Packard and Finnegan, in which you state that they say it's appropriate to identify a compound based on the detection of a single parent and single daughter ion?
It's his testimony.
I don't know what to ask them. I'd have to look and ask Hewlett-Packard whether they have a copy.
Is the observation or detection of a single parent and single daughter ion. Are there such articles, sir?
I believe yes. I think there are, and I think I could locate them.
And if you would, please try to locate them over the lunch hour.
No, I can't do it over the lunch hour because I'd have to go back and do a literature search.
Then you will forward it to us when you get back to your lab.
If I find it, I will. If not, I'll send you a note I haven't found it. Is that satisfactory?
That's fine. Thank you, sir. Now, would you say that the number of hours total that you've spent on this case was over 100?
Including the time I've spent here, I would say probably.
What experiments have you conducted since September or October when you were retained in this case in 1994 to prove that EDTA will degrade in sunlight?
Asked and answered.
We asked that question on the 24th.
What experiments have you conducted since September of 1994 to prove that EDTA will degrade if it is left on metal?
1. Objection. Asked and answered. 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 1
What experiments have you conducted to determine whether EDTA will degrade when it is on paint?
Yeah, objection asked and answered. Counsel arguing.
Sustained. Why don't you just ask him the omnibus question? Did you
All right.
conduct any experiments regarding degradation?
Did you conduct any experiments, sir, with respect to the degradation of EDTA when exposed to any kind of compound or element?
No, I looked at the literature, but I haven't done any experiments myself.
And is there any literature that you're aware of that determines that is based on experiments to show that EDTA will degrade in the presence of paint or metal or fertilizer or rust?
There's lots in the literature about the breakdown of EDTA.
Objection, non-responsive.
And as far as in sludge, which contains all those things, yes.
Dr. Reeders, is it your testimony that there are articles based on experiments that show that EDTA degrades when exposed to paint or metal or fertilizer or rust?
Specifically to those substances only, I'm not aware of.
Would this be a
Now,
good
it's
spot?
yes, that's fine.
Excuse me, except for Dr. Martz's experiment.
All right, ladies and gentlemen, we're going to take our recess for the noon hour. Dr. Reeders, you can step down. Please remember all of my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't conduct any deliberations until the matter has been submitted to you. Don't allow anybody to communicate with you with regard to the case. We'll stand in recess until 1:30. All right. All right, back on the record in the Simpson matter. All parties are again present. We have a few evidentiary matters to take up before we invite the jurors to rejoin us to conclude with Dr. Reeders. All right, Mr. Ullman, do you want to be heard on behalf of the proponents?
Yes, sir.
Good afternoon, sir.
Your Honor's ruling last week with respect to the access to the report of the Internal Affairs investigation and the reporter shield law were very careful, narrow rulings addressing essentially the admissibility of false leaks, as Your Honor characterized the information in terms of fabrication or disinformation, primarily with respect to the defense contention that blood was planted on the sock. And the court concluded that it was speculative to infer, even if a source of the disinformation were the LAPD, that the source participated in the planting of evidence or spoke directly with someone who did. We accept that ruling, even though we disagree with it. My purpose today is not to seek a reconsideration of that ruling. But the issue that we'd like to address today is a broader one, and that is whether the leaking of accurate information by the Los Angeles Police Department is material and relevant to the defense. And in addressing this broader issue, we would ask the court to take a broad view of the defense theory of this case in the terms in which that theory will actually be argued to the jury. This aspect of the defense in this case has frequently been mischaracterized by the prosecution, and I think that's part of the problem. In questioning witnesses, they've asked witnesses whether they are part of an elaborate conspiracy to frame Mr. Simpson. And that kind of sarcasm completely misses the real thrust of the defense in this case. We don't have to show an elaborate conspiracy to frame an innocent man. In fact, an elaborate conspiracy would be inconsistent with the pervasive ineptitude that has characterized both the investigation and the prosecution of this case. Our defense quite simply, is not that there is an elaborate conspiracy, but simply that the evidence in this case cannot be trusted. It cannot be credited. It lacks integrity. That's the defense. And no one should be convicted of a horrendous crime and be deprived of his liberty on the basis of evidence that cannot be trusted. Now, we've offered a number of reasons why the evidence can't be trusted. First, some of the persons who collected or handled the evidence are corrupt. There are individuals involved in this case who are capable of planting or manufacturing evidence, and who did so in this case. Secondly, some of the persons who collected or handled the evidence in this case are incompetent. Acceptable professional standards for the handling of evidence were not met or maintained, and the documentation that accompanied the collection of the evidence lacks credibility, lacks precision. Thirdly, some of the persons who collected or handled evidence in this case are careless, that the sophisticated scientific testing is of little use if evidence has been contaminated by careless handling. And finally, some of the persons who collected or handled evidence in this case are manipulative. The goal of this investigation was not a search for the truth, but a search for the restoration of a tarnished image. Evidence and information were handled in ways not designed to assist the court, but in ways designed to enhance the public image of the Los Angeles Police Department. I think it's often overlooked that the motive to plant blood on a sock or on a gate may not have been to frame an innocent man. It may have been done by persons who were convinced that Mr. Simpson is guilty and who were concerned that previous screw-ups had compromised the ability to prove that guilt in a court of law and would have to be enhanced by extracurricular efforts. Now, the motive doesn't make any difference. We don't have to prove the motive. The integrity of the evidence is just as questionable whether it was done to frame an innocent man or whether it was done to restore the tarnished image of the Los Angeles Police Department. And in addressing the materiality and the relevance of the leaks, we believe the appropriate question for the court to ask is, does evidence of leaks, even of accurate information, by the Los Angeles Police Department assist the trier of fact in answering the question, should I trust evidence that was collected and processed by the Los Angeles Police Department? Knowing, for example, that reports of scientific test results faxed to the Los Angeles Police Department were given to newspaper reporters before they were given to prosecutors or to defense lawyers or to the court in this case. Does that tell you anything about the competence and care of those who were entrusted with maintaining the integrity of this evidence? Now, while Your Honor has suggested that the leak of September 21st was a fabrication, we would ask you to just put to one side the false part that DNA tests had already been conducted on those socks. The reports were accurate in leaking the information that blood had been uncovered on one of the socks or discovered on one of the socks, and that this blood had been linked to the victim, Nicole Brown Simpson, by means of testing, even though the part about what kind of testing was conducted was inaccurate. And if you look at the timing of the leak of that information, the part of it that is accurate It comes the day after the LAPD laboratory conducted a test to show the PGM subtype of the blood on that sock, and the knowledge even that that test had been conducted had not been transmitted to the defense, to the prosecution, to the court, and the leak came on the same day that this court made a finding of recklessness on the part of the chief investigating detective in the course of pretrial motions in this case. That finding, the court will remember, was made on September 21st, 1994. And it doesn't take a rocket scientist to conclude that what was going on may have been news management, controlling the spin. And aren't we entitled to ask, do you trust evidence collected by the Los Angeles Police Department in this case, knowing that the security and confidentiality of evidence was manipulated in order to shape public opinion? We can put to one side whether its purpose was to manipulate public opinion against OJ Simpson, knowing that a jury was in the process of being selected. Assume that wasn't even the purpose, that it was to manipulate public opinion in favor of the Los Angeles Police Department on a bad news day when the LAPD was taking a hit. The result is the same. And the result is we have less trust in the LAPD. We have less confidence in the evidence that they collected and handled. And finally, I would ask the court to consider the materiality and relevance of this evidence as rebuttal to contradict the testimony of key prosecution witnesses. The testimony, for example, of Detectives Van Adder and Lang, that the investigation conducted in this case was a thorough and professional one consistent with their years of long experience as homicide detectives. The implicit message of that testimony was simply, you can trust us, and you can trust the evidence we collected. And the lapses in procedure, such as bringing a blood vial of the suspect back to the scene in a coat pocket, were minor and inconsequential and don't affect the integrity of the evidence.
Actually, I thought it was in a gray envelope.
A
Gray envelope.
Well, you're right. It was in a gray envelope. Bringing it back to the crime scene, however, certainly was a departure from normal procedure. And there have been lots of departures from normal procedure that have been brought out in this case. And those departures raise questions. And the counter to those questions has been, you can trust us. You can rest assured that the evidence was handled with integrity. And that's the relevance of these leaks, because it suggests to the court, to the jury, as the finder of fact, that you need to really wonder about how much confidence you can have in this evidence, how much trust you can have in those who collected and processed it. There's also the testimony of Mr. Matheson with respect to elaborate special security established for the security of the evidence in this case. I mean, they really describe the evidence control facility as a Fort Knox. And if penetration of that level of security was possible to manipulate information by selective leaks of that information to the press, that raises an inference. And that inference is a question. Can you really trust that the evidence was as secure and as safe from any tampering, from any contamination, from any compromising, as the prosecution would have us believe? Now, of course, there's lots of other evidence to support the defense case, to show that there was corruption, there was incompetence, there was carelessness, there was manipulation. But the test of materiality and of relevance is not whether the evidence is needed to prove a fact that can't be proven by any other means. It's whether the evidence supports an inference which is of consequence to this case. And I can't think of any greater consequence to this case than the integrity of the evidence, the degree of trust we have in those who collected and handled it, the degree of confidence we have in their credibility. Now, Your Honor mentioned in your order that leaking is nothing new, that from the Pentagon Papers to Watergate, we have seen leaks used to manipulate the press and to put a spin on information. And one reason may simply be that those who are entrusted with sensitive information don't deserve to be trusted. And one consequence of a breach of that trust should be when it is exposed, they have to answer for it. And one place you answer for it is in a court of law, in which you are coming in and seeking to persuade a finder of fact, you can trust us. You can have confidence in the way we handled this evidence. And that is precisely why we believe it is relevant to show that these leaks came from the Los Angeles Police Department, leaks of accurate information to undermine the trust that the jury should have in the integrity of the evidence.
Mr. Allman, what are the specifics of your offer at this point? What do you intend to present?
We would like to present simply a confirmation of the accuracy of the published reports with respect to accurate information. That is, that the leaks of the faxed information from Cellmark that came to the LAPD on September 12th actually appeared published in newspapers before they were delivered to the defense or the prosecution in this case. We believe we can separate the truthful part of the report of September 21st from the untruthful part. We would not offer the portion relating to DNA testing, but we would offer the portion relating to finding blood on the socks, to an attempt to link that blood to Nicole Brown Simpson, and showing that this information was published, appeared on television before that information had been conveyed to this court. And we would also offer Mr. Bosco's report with respect to the active attempt to shop information around to news media, regardless of a showing that that information was false or inaccurate.
Thank you. Mr. Goldberg?
Good afternoon, Your Honor.
Good afternoon, Mr. Goldberg.
Kind of reminded here of one of those monster movies that we've all seen where the monster is impaled and burned and stabbed, and just when you think it's finally going to rest, it rises up again out of the ashes.
You're probably speaking of Friday the 13th.
Yeah, I think so. I'm referring here, of course, to the matter now before the court, not Professor Ullman. Your Honor, when we spoke very briefly about this issue on Thursday, it was mostly in the context of scheduling. I made a comment to the court to the effect that I felt this was a simple issue. And I just wanted to say to the court that I fully appreciate the complexities of this litigation that have confronted this court. And I did not mean in any way for that comment to in any way underestimate or be contrary to my appreciation of the extraordinary task this court has to face, perhaps one that no other judge has had to face before in any litigation, in terms of the number and complexity of the legal issues, the number of lawyers on both sides.
Well, wait till you see asbestos litigation.
Well, and the shortened pretrial and the extensive media coverage. And I simply wanted to make it clear to Your Honor that that comment in no way was meant to in any way derogate my appreciation of those complexities. What I did mean by that, Your Honor, and perhaps it was a little bit misstated, is that in our view, this isn't a simple issue, but it is a non-issue or an issue that has already been resolved. In other words, that Your Honor has already made all the rulings and all the decisions that are necessary in order to determine the admissibility of this evidence. And that is that Your Honor has already made a determination in the context of discovery issues that the evidence here is not material. And in going back to the record of the arguments that I believe took place on Wednesday, the court started out by deciding the question of whether or not this evidence was going to be sufficient, or the prima facie showing was sufficient for the purposes of discovery of police personnel records. However, the court's written ruling only addressed the issue of the Shield Law, but the court actually disposed of both discovery issues, one orally and the other in writing. And during the oral pronouncement of ruling, the court said that this record does not support a finding that access to the results means access to the evidence itself. That assumes that access to the results does not exist in this case, and the mere fact that the results as reported were incorrect is a clear indication to the court that the source of this leak did not have access to that information and was not a source close to the investigation and was not, in fact, knowledgeable. The court then went on to state that under the Delaney test as well, the court was making a finding that the entire record does not support a finding of materiality. So the court did not rule, as counsel, I think, has suggested, that this evidence wasn't relevant on the issue of suggesting that evidence on the socks was planted. The court ruled that it was not material, period, under a variety of theories that were proposed by the defense. Now, in trying to count what was just said here this afternoon by counsel, it looked like he said approximately 3 things, or offered 3 alleged areas of relevancy of this evidence. He said something that I think is essentially the same as his rush to judgment argument, that the fact-finding process was not an objective search for the truth. I've already extensively argued that. Counsel has on a number of occasions, and the court rejected that as being a basis for materiality. The second thing that he said was that it shows that the handling of information was not trustworthy, and therefore it undermines the confidence that the jury should have in the maintenance of the security of the evidence. And the court heard and rejected that argument as well. There is no logical connection between the two. And then the third argument that I heard counsel make today, which I also believe was made when we last argued this, was the argument that this was an effort to shape public opinion on behalf of the Los Angeles Police Department. And as the court can recall, my response at the time that it was first made was that if some police officer somewhere out giving traffic tickets was proselytizing that, in his opinion, the defendant was guilty and the evidence overwhelming, that clearly there could be no possible relevance to that case. So this issue, again, was argued and rejected by the court. The court has very simply found that this isn't material. Now, we suggest that that disposes conclusively of the evidence in this case, because as I believe the court's comments indicated when we argued this issue last, the issue of materiality for relevancy purposes is only different from the issue of materiality for discovery purposes, insofar as for discovery it would be a slightly lesser standard, because the issue there is whether or not a prima facie showing can be made that they're going to discover evidence which might be beneficial to the defendant. They don't even have to show that it's necessarily going to be admissible per se. So here the standard is higher in terms of materiality than it was at the time that the court was ruling in the context of a discovery hearing. So we would suggest, and we are very confident in this, and I think the court's comments are consistent with this, that it is not logically possible for the court to rule that this evidence, which was so immaterial that the court wasn't even going to allow further discovery on the issue or further exploration, to perhaps give the defense the opportunity to shore things up a little bit. It was so immaterial for those purposes, is nevertheless sufficiently material that not only should it be admitted, or not only can it legally be admitted in front of the jury and overcome a relevancy objection, but it could also overcome an evidence code section 352 objection that it is more probative than prejudicial. Those two positions are irreconcilable. The court cannot logically come to the conclusion that it's so irrelevant that no further discovery should be allowed, and then at the same time conclude that it's sufficiently material and probative under 352 to come before the jury.
But didn't we hear a different offer today? The offer being that actual accurate, yet arguably premature disclosure of information is somehow relevant. That's a different argument than we heard before.
Yeah, somehow relevant, but relevant to what? He said it's relevant to rush to judgment, relevant to mishandling of information, and relevant to an effort to shape public opinion. And all those arguments have been previously made. So what I'd suggest to the court is this. I think we all recognized that to the extent that the defense was unable to show that this was an individual close to the investigation, that all of the arguments of relevancy were extremely tenuous. And we gave the elevator example of someone overhearing in the elevator, and counsel was never able to come up with a satisfactory explanation of how on earth that could be relevant. But they also couldn't show how it could be relevant even if a source much closer to the investigation had heard it. So if the court was not going to give them the opportunity for discovery purposes, at least to try to pinpoint how close this individual was to the investigation, then how can we say in the absence of knowing that information at all, and in a record that leaves us to believe that the elevator operator possibility is equally reasonable as the investigating officer possibility, how in the state of this record, where either of those inferences is equally reasonable, can we say that this is relevant for the purposes of admissibility? I don't think we can. And it's of great concern to the people, Your Honor, not only, of course, that the court make the correct rulings, and we believe that Your Honor has, especially in this regard, and you gave it an enormous amount of attention and heard an enormous amount of argument. And we recognize that this is an issue that is largely an issue, mixed issue of law and fact, and therefore subject to the trial court's discretion. It's not only important to us that you make the right rulings, but it is also in the people's interests that the record is consistent, so that if we get to the point, as we believe we will, where a reviewing court is looking at what the court did, they will be able to understand that Your Honor exercised your discretion, understanding completely what the legal standards were and correctly understanding the law that applied. And we believe that saying that this is admissible evidence, already having ruled that it's immaterial for discovery purposes, is so illogical and so inconsistent that we would be concerned about the inconsistency of those two rulings for purposes of the record. And if the court for some reason is now going to reevaluate all of these issues, and we certainly don't think the court should do that, that the court would also have to reevaluate these issues for the purposes of discovery as well in order to be logically consistent. And that would be the only way of doing it. And then Your Honor would have to, in effect, say, well, if this is the kind of thing that can go before the jury, maybe we should give the defense the opportunity to shore it up a little better. Now, we've argued over and over again as to why it's irrelevant, why it's immaterial. And I hate to repeat those arguments again here, Your Honor. I just don't think that we should. I think that Your Honor has ruled. I think the court should simply decide that your previous rulings are dispositive of the issue now before Your Honor. Maybe there's some additional question I can answer. Maybe Your Honor feels that they've somehow materially phrased the issue differently, and I haven't adequately addressed that. If that's the case, I'd like the opportunity to do so.
Well, as I posed to you, the offer that was given just now by Mr. Ullman included the true reporting, however, arguably in a premature manner.
Of what? Of the SOX?
Of events, any event.
But
focusing, for example, on the PCR testing that was conducted by Cellmark and reported to the Los Angeles Police Department. My recollection is somewhere around September the 8th, yet those results were not transmitted to the district attorney's office until approximately the 14th is my recollection of the record. However, the news reports appeared in the Los Angeles Times regarding that testing on September 11th. Is my recollection of the record. The dates may be a day off or two.
Now, previously, the defense only wanted to introduce reporting as to the SOX. Maybe now they're broadening it and they also want to introduce other reporting. I don't know.
That's what I heard Dean Ullman to say.
Okay. And then we have to ask ourselves, what is it relevant to? I mean, just saying, well, it's relevant, we'd like to get it in, doesn't do it. What is it relevant to? I think that they're now conceding that Your Honor has decided that none of these leaks, so-called leaks, are relevant to the issue of the SOX and planting evidence on the SOX. It doesn't go to evidence planting. Does it go to bias? Well, we'd have to know who on earth was responsible for the leak before we could even get to the issue of bias. So it doesn't go to that. We've heard rush to judgment, and we've argued previously that this whole question of rush to judgment is not an issue because the subjective mental processes of the investigating officers or the prosecutors is not relevant. If it were, as I previously stated, we'd need expert testimony as to what a reasonable police officer would have believed in terms of the defendant's guilt and when he would have formed those beliefs. And then they'd be entitled to call an expert in rebuttal to suggest to the contrary. It would just take us down a path that would lead us into a form of inquiry and a type of inquiry that's totally irrelevant here. The jury has to decide this based upon the objective persuasiveness of the facts, not whether they think that the detectives correctly evaluated those facts. Is it relevant to show some sort of an effort to shape public opinion? Well, if it is, then does the prosecution get to put in the numerous press conferences, I guess you couldn't call them leaks, by the defense in their efforts to shape public opinion? You know, there are many people watching this trial that do believe that there is a conspiracy of sorts who would characterize that conspiracy to obstruct justice in their minds as emanating from the defense's efforts to try to saturate public opinion with their particular viewpoint and their particular spin on this case. I don't think that's admissible. I mean, whether it's proper or not, whether it should be done or not, it is not admissible. So are we going to be able to get in that evidence? I do not see any logical theory as to how on earth you can try a case based upon information that has been given to both sides by the press, especially when they can't even pinpoint, and there's no way of being able to pinpoint who on earth was responsible, if anyone for sure, of giving this information to the press. Now, with respect to the admissibility of this evidence, Your Honor, there are some other issues that I'd like to get to, but I don't think I need to unless the court somehow decides that it's going to reevaluate the very carefully worded written decision, an oral decision that Your Honor already made. But those other issues include things like hearsay, absence of foundation, the fact that a lot of this evidence would require witnesses to offer inadmissible opinions as to who it was that they were speaking to without foundation, as to how they know who they were speaking to. There are a lot of other legal issues dealing with authentication, dealing with hearsay, dealing with opinion and conjecture. But I would prefer, with the court's permission, not to address those at this point. And there's also another issue beyond those as to how we are going to cross-examine witnesses who would only give us partial information and invoke some kind of a shield in order to prevent any kind of meaningful cross-examination. I would simply offer conclusions and opinions without allowing us to try to figure out what the basis for that conclusion and opinion is. With Your Honor's permission, I would ask to be allowed not to argue those right now, and I previously argued them in other contexts before anyway, because they are not relevant if the court concludes that its rulings are already dispositive on this issue.
Thank you.
Thanks.
Mr. Ullman.
Your Honor, with respect to the dates of the Cellmark leak. I believe it was a report from Cellmark dated September 8th that was faxed to the Los Angeles Police Department on September 12th, and then subsequently refaxed to the prosecutor on September 16th. And it appeared in the Los Angeles Times, I believe the 14th or 15th, before it had actually been delivered. Mr. Goldberg's first point seems to be that all of these questions and issues have already been argued and rejected. And of course, Your Honor is the best judge of what you have previously rejected. We believe that the prior ruling was based on a very narrow premise addressing the admissibility of false information being leaked. And what we're talking about here is just the accurate information. And we're not going to try to evade Your Honor's prior ruling by offering evidence of false information being leaked and argue from that we can imply there was some connection with the actual planting of evidence on the sock. We realize Your Honor's ruling has foreclosed that. But what we're talking about here is a different inference drawn from a different fact, inferring from the fact that accurate information was leaked to the news media before it was delivered to the prosecution or the defense, that in and of itself gives rise to some distrust of the attempt by the Los Angeles Police Department witnesses to create the impression with this jury that the evidence was very carefully handled, that the information was kept in very secure form, and therefore that they need not be concerned about any risks of compromising this evidence. And quite simply, that is a faith, that is a trust they should not have in the evidence based on the performance of the Los Angeles Police Department in this context, in the context of leaking information. Mr. Goldberg makes the point that the standard of materiality is actually more liberal with respect to discovery than it is to actually offering the evidence. But what he overlooks is that here we have the evidence. What we are seeking to offer is actual publication of information and to show when that information was published as opposed to what kind of control existed over the information at the time it was published. There's no hearsay problem because we're not offering this to prove the truth of what is asserted. We are simply offering it to prove when it was leaked, when it was released. And authenticating that will be a very simple matter. In fact, we already in the 402 hearing heard the testimony of Michelle Kessler that very carefully defined who had access to this information at the time it was leaked. Now, Mr. Goldberg says, well, we can't show that someone close to the investigation was responsible for the leaking. It is a logical inference. If the testimony is that information was tightly controlled, that the number of people who had access to that information can be counted up and accounted for, that if the information is then published, the only explanation can be that those people who were responsible for its integrity and for its security were either corrupt, incompetent, careless, or manipulative. And that's precisely the question that we're raising about the handling of the evidence in this case. And finally, Mr. Goldberg did not address at all the question of the relevance of this evidence as rebuttal evidence to the testimony of the detectives, of the lab technicians who described a procedure in order to enlist the trust of the jury set up to maintain the security of this evidence.
Thank you, counsel. All right, the issue before the court is the relevance of the proffer just made by the defense regarding leaks of information, most of which turned out to be accurate information, some of which was decidedly inaccurate. The issue being whether or not premature disclosure to the news media before it's known to the prosecuting attorneys or before it's known to the defense or the court is probative of some of the issues that have been raised in this trial. The defense is quite correct that they have vigorously raised before the triers of fact challenges to the competence of the individuals who collected the evidence, have raised issues regarding carelessness in its handling, and those issues are before the court, both through the cross-examination of the prosecution's witnesses and the testimony of the defense witnesses that have been offered to date. The problem that I have with the offer is that the probative value of news information, the probative value given what it attempts to prove is very slight, to the point of being irrelevant. And under Evidence Code Section 350, I will exercise my discretion and make a finding that it is not relevant. Also, I viewed this in light of Evidence Code Section 352 as well, in that given its slight, if any, probative value, the time that would be required first to present it, and then to allow the prosecution to rebut it by bringing in timely news information would be an undue use of the court's time. I'm reminded of the Callahan cartoon that's often published regarding what the legal process appears to have become. And this is not a trial by news media sources, leaks, tabloids, or otherwise. The objection will be sustained on both grounds.
That Ms. Savage be released from this particular congressional since there's no relevant testimony that she can offer.
Same with respect to Mr. Bosco, Your Honor.
I have no idea what other relevant information they may have. As to these two issues, the answer is yes, I'm making a finding that they have no relevant information to offer. I have no idea.
Your Honor, let me just respond as far as Mr. Bosco. We will release him.
All right, how about Ms. Savage?
To Ms. Savage, we'd like to confer on that.
All right, Ms. Sager, I understand your client is out of town, not due back until the 21st.
But if there's going to be another opportunity or request to bring her to the stand, I'd like to be heard and have an offer of proof made as to what possible relevant evidence she can offer, given that the court has now ruled that any evidence with respect to inaccurate portions of her report cannot be offered, and that any accurate portions of her report cannot be offered. I fail to see what's left that Ms. Savage can testify about. She's not the custodian of records, so if the tapes are or are not going to be introduced...
Well, counsel, let's not argue the issue now. She's out of town. Counsel have declined to release her from the subpoena. We'll take it up on the 21st if they insist on calling her to the stand. All right, it's premature. Thank you, counsel.
All right, in light of the rulings you just made, I need a little bit of guidance because the very next witness, as you know, is Michelle Kessler. And it's my understanding from the court's rulings that obviously testimony even regarding reliable and accurate leaks cannot be disclosed to this jury through either Bosco or Savage. My question has to do with Michelle Kessler. And in terms of timing, I can talk about this now if you'd like, or we could take a short recess after we finish this witness so I can make the applications at that time if you'd like.
Let's finish Dr. Reeder's first.
Okay.
And then we'll see where we are in terms of Kessler. We also have counsel here in the courtroom who represent Mark Furman, who wanted to address the court on certain issues.
Okay.
All right, counsel.
Morning, Your Honor. My name is Lori Butler. I'm Robert Turtelow's partner.
Good afternoon, counsel.
And we are here basically as a result of finally having obtained a copy of the protective order that was issued with respect to the Laura Hart McKinney tapes. And specifically, I would reference the court to two things. My partner sent you a letter referencing his concerns about the confidentiality with which the tapes are going to be maintained and the right of counsel for the defense to make commentary about such tapes on such shows as Larry King Live and other television and radio programs. Those concerns were expressed by Mr. Turtelow. We are also here, Your Honor, this afternoon to seek access to the tapes on behalf of Mr. Furman. The reason we are seeking such access is that, first of all, the order was made in our absence without our knowledge and without any opportunity on behalf of Detective Furman to object to or make any statement with respect to his interests, and we believe he does have an interest in these tapes. They are his voice in great part, and again, I am speaking without having heard the tapes because we have not had access to the tapes, but it is my understanding that they represent a dialogue between Ms. McKinney and and Detective Furman, which was to form the basis for a Hollywood screenplay. With that in mind, I think the attorney for Laura Hart McKinney has noted in an LA Times article which appeared on August 12, 1995, that there was some sort of business relationship between Detective Furman and Ms. McKinney. And from that, I think it's implicit that Detective Furman has rights to those tapes. And
I'm sorry. Are you arguing that because it's reported in the LA Times that I should take that as
No, I'm not, Your Honor.
evidence of a business relationship?
No, I'm simply pointing to that as a statement by the attorney, by the purported owner, the woman who has claimed before this court and other courts that she is the owner of the tapes. We are taking the position, and we are representing to this court, that to the extent that the Detective Furman's voice is on that tape, and he is an author of the statements in that tape was to be used ultimately for a screenplay. It is categorized in the protective order as intellectual property, which connotes a creative sort of written or transcripted creation, that Detective Furman has some rights to these tapes and certainly has a right to access to them along the same lines as has been given to the defense counsel, the district attorney, the court, and their respective support personnel.
All right, Ms. Butler, let me ask you this. Did your client, Mr. Furman, have a contractual consulting agreement with Ms. McKinney, which includes access to the materials, copies, transcripts, et cetera?
It is my understanding that the relationship was one where he was to be involved in the ultimate exploitation of these tapes on some basis. I do not know the exact nature of the contractual terms because this was a relationship that evolved and the taped sessions occurred over several years, and the tapes were never ultimately reduced to a screenplay or a published work, but he clearly has rights in those tapes, and it would seem to me, Your Honor, that he would have a right to at least hear what is being said. And let me just focus on the second concern, and that was what my partner expressed, which is, and as I read the order, it does not bar anyone from voicing publicly their reaction to the tapes, whether they found them to be upsetting, to be chilling, to be anything. Once that happens, you have a body of tapes which have been characterized by one party with no prohibition by the court. And there could be further injury and defamation to Mr. Furman, Detective Furman, and he has no ability whatsoever to rebut any of this because he's been denied any access to his own voice.
Ms. Butler, has your client made any requests of Ms. McKinney for a copy of the tapes for transcript?
He is making it through us at this time, Your Honor.
Well, the person who actually has the possession and control of the tapes and the transcript is still Ms. McKinney. What has been transmitted to the court is a copy. Have you made any inquiry of Mr. Schwartz or Mr. Regwan regarding Ms. McKinney's?
I'm going to defer to Mr. Town because he has made those attempts and he is our co-counsel at this point, and I'll let him address that because he had made that inquiry.
All right. Good afternoon, Mr. Town. Would you spell your names for the court reporter, please?
T-O-W-N-E.
Thank you.
Richard Town for Detective Furman. On Friday, I attempted to contact Mr. Schwartz at his office. I left a very detailed message advising him of our interest, our representation, and our concern. Because we understand, without having had the same access that other parties involved in this matter have had to the tapes, that they are protected and protectable, and that Detective Furman has a right, an interest in those tapes under perhaps the copyright law, under perhaps California's common law with respect to the protection of ideas disclosed in a confidential relationship. And the upshot, I have not received, at least as of the last time I checked my office today, any response from Mr. Schwartz. Having been provided a copy of your order, we can see, I think there is great significance to the fact that Mr. Schwartz characterized the tapes and the other material as intellectual properties, suggesting, properly so I believe, that they are creative works of fiction, created for dramatic purposes for subsequent exploitation in a commercial context. We have now a situation where, pursuant to the court's order, one, if not the creator of this potentially valuable, and we say potentially valuable because Mr. Schwartz has so characterized the material in excerpts and articles from the Times, we have those potentially valuable properties outside of Detective Furman's access, custody, control, or review, where their authenticity and in fact the manner in which they've been maintained in custody over some years has not been determined. And I think it ought to be determined. So our situations, we would like equal access to that which the parties, pursuant to the court's order, now have.
All right. Have you consulted with counsel for either side, either the prosecution or the defense, and asked for their cooperation in contacting Ms. McKinney for this purpose?
No, we have not had the chance to do so, but would like to do so.
All right. The people have any position?
Sounds to me like they're asking for Detective Furman's right to know what's on the tapes and in the transcripts, and as long as the proprietary interests are preserved as indicated in the court order, the protected order, people really have no position.
Mr. Cochran?
Regards Mr. Simpson, the problem is, and I don't have to give this court the history of what happened in these tapes. We're the ones who went and got these tapes. What the court has is a copy, which I arranged to have brought out here, or what the court will have shortly. What counsel has is a copy. These are impeachment. They don't have a right to these tapes. Furman doesn't have a right to these tapes. What they should be doing is talking to Matthew Schwartz and Ron Regwan. regarding these tapes. I'm glad they admit it's Mr. Furman's voice, and it is his voice. This is not a screenplay, it's dialogue, and it's an interview is what it is. It's called an interview with Mark Furman. Now, we have no desire and will not, short of an order from this court, turn anything over to them, because this is our impeachment of a witness who's still on the stand in cross-examination in a criminal case. And that's the issue in this case. And the court knows beyond that where this case is going to be, where we expect this case to go beyond this. So we're not going to cooperate with them with regard to this. They can talk to their client if they want to know what he says. He can tell them what he said over the last 10 years. We feel very strongly about this. It's the fruits of Mr. Simpson's lawyers' labors. And we are now going to use those, as the court knows, for impeachment of this witness and beyond this trial. And so we feel very strongly about it.
May
All
I
right.
respond?
Yes, Ms. Butler, the problem I have here is that under the discovery laws here that govern the conduct of this case, the defense has no obligation to disclose information that they are going to use for the purposes of impeachment, which they claim these tapes are. So I don't feel that I'm in a position to order them to turn this over to you. However, it seems to me that what you have is at this point in time, a civil dispute with Ms. McKinney regarding whose property these really are. And I would assume that she would be cooperative with Mr. Furman and his counsel in turning over a copy of the tape and of the transcript, because she cooperated with defense counsel. When the prosecution counsel made contact with her, she was also cooperative with them immediately upon learning that they wanted to have a copy, and in fairness, gave them a copy and subjected them to the protective order. I assume that because of the relationship between Mr. Furman and Ms. McKinney over a number of years, she would, at least out of a sense of fairness or obligation, provide him with the equal access, a copy, and the transcript. But do you understand the dilemma that I'm under, that I'm here in a criminal trial?
No, I certainly understand. My concern was, it seems to me that the protective order really at this point precludes us from getting access to the tapes by virtue of the wording limiting the parties that may have access to it solely to those defined in the protective order.
Well, I don't.
And I don't know whether Ms. McKinney or her attorney has the right to unilaterally, at this point in time, disseminate tapes to Detective Furman or his counsel, barring a further order of this court, which is why we were here. If we felt we could accomplish this solely through a dialogue, a request, an agreement with her or her attorney, we would have done that. And we did try to do that, but we got no response. But we feel, having learned about the order and having first seen it today, that
Counsel,
that's where we are.
let me do this. Let me have my clerk call Mr. Schwartz's, Mr. Regwan's office.
Okay?
I'll ask them if they're willing to cooperate with you if we clearly modify the protective order to allow Detective Furman and his counsel one copy with an order against any additional duplication, and see if they have any objection to providing that to you within 24 hours.
All right.
All right, so why don't you stand by? I'd like to finish my jury trial this afternoon, so I'll have Mrs. Robertson or my law clerk, Mr. Byrne, make the contact with Mr. Schwartz and Mr. Regwan, and we'll see if we can accomplish it the easy way.
Okay, thank you, Your Honor.
All
Thank you
right.
very much.
Don't go away.
We'll be back here.
All right, Mr. Ming, would you make sure that Mr. Byrne takes care of that? Thank you.
I just inquire with respect to Ms. Kessler, when it is we are going to meet her, if at all, this afternoon. We did agree to the defense, apparently, that we have her here when they needed her, so I just like to.
Well, we still have a 402 issue before she testifies. We must conclude Ms. Clark's cross-examination, Mr. Blazier's redirect, Ms. Clark's recross. So, and it is now 2:30, and this is a 5 o'clock day. So my guess is we would get to her 4 o'clock, but that would be starting the 402 hearing. So my understanding is that she's at Piper Tech, correct?
Right.
Which is 10, 15 minutes away. So why don't you leave her on call?
Thank you.
All right. Is that agreeable to you, Mr. Neufeld?
That's fine, Your Honor.
Okay. But she is available.
I spoke to her about an hour ago she was.
Okay.
Maybe because you're, sorry.
With reporter? All right, Deputy McNair, let's have the jury, please. How much more do you have?
How much left? 10 minutes? Well, you know what I mean.
Okay.
No, you know that's Mr. Cochran. No, that was fair. You know I'm not like that. I'm anticipating multiplied by 10, the answers will make it 30, so.
All right. All right, Dr. Readers, why don't you come on up? Seated. All right, let the record reflect we've been rejoined by all the members of our jury panel, that Dr. Frederick Readers is on the witness stand undergoing cross-examination by Ms. Clark. And Ms. Clark, you may continue.
Thank you, Your Honor. Good afternoon, ladies and gentlemen. Sir, I've conferred with your counsel, and he tells me that you have billed so far $13,000 for your services.
Yes.
Does that sound right to you?
Correct.
That does not include your time in court today, is that correct?
Correct.
What else does that not include?
Anything since June 16th.
And there were hours spent after June 16th, I take it.
Yes.
Do you know how many hours were spent after June 16th, 1995?
No.
Can you estimate for us?
Honestly, I can't.
Whatever the number of hours they would be, it was your testimony, I think, earlier that you bill at the rate of $250 an hour, correct?
For actual work that pertains to the case, not just time spent, but actual work pertaining to the case. Some of the work is I'm learning things. I don't bill for that.
All right. In this case, sir, did you spend actual time working on the case since June 16th, 1995?
I can't tell you.
You can't tell us.
I don't know.
At some point, you will submit a bill for those hours, will you not?
Yes, I hope to after I return this time.
And we cannot obtain that information right now.
Overruled.
I know it'll be over $10,000, but I don't know whether it'll be 12, 20, or 30. I really don't. I know it'll be over $10,000 because I can just see in my head that I've spent more than 50 hours right here in Los Angeles.
Mm-hmm. All right. Then that would be another over 10,000 in addition to the 13,000 you've already billed, correct?
Yes.
Now, sir, if you will recall on July 24th, when I pointed out to you that the gate and the sock gave very similar readings to Agent Martz's own unpreserved blood, your answer was yes, surprisingly yes. Do you recall that?
Yes.
And when I asked you how you could account for that, you stated that you could not account for that, and you called the results of Agent Martz's unpreserved blood absurd. Do you recall that testimony?
Approximately, yes.
Would it help you to determine whether or not that is exactly what you said if I showed you a transcript of that testimony?
If that's what it says, I'll concede to it. If you have it right there, I don't want to spend any more time on it.
Would you like to look at it, sir?
No, not particularly.
Now, when you called the result on Agent Martz's blood absurd, it was your testimony that you felt it was absurd to find that amount of EDTA in normal blood, correct?
That's my opinion, yes.
Now, after you wrote your report on July 17th, sir, the chromatographs depicting the readings on the gate and the sock stains did not change, did they?
I don't know what you...
The graphs that were generated by the testing performed by Agent Martz on the gate and the sock stains were the graphs that you examined from March until you wrote your report on July 17th, correct?
Yes.
Those graphs did not change after July 17th, did they?
I didn't see any change, no.
And yet, in that report on July 17th, as you previously testified, you wrote that your interpretation of those graphs revealed the presence of one parent and one daughter ion on the sock stain and on the gate stain, correct?
Yes.
And then, after you wrote the report on July 17th, and the graphs did not change, you did get the results of Agent Martz's blood that gave the same one parent and one daughter ion result, correct?
Yes.
And then you testified on July 24th that you found then that the sock chromatograph showed the full daughter spectrum, which had not been contained in your July 17th report, correct?
Yes.
Now, given the result, isn't it true, sir, that given the result on Agent Martz's blood, you realized that you could not maintain that the substance detected on the gate and the sock stains came from preserved blood unless you changed your opinion as to what the graphs showed on the evidence stains. Isn't that true?
No.
You did change your opinion, however, with respect to what was shown on the graph for the sock stain. Isn't that true?
No.
But your report said did not document a full daughter spectrum, did it?
It said nothing about the full daughter spectrum.
In fact, it affirmatively said one parent and one daughter. Isn't that true?
That's the only things it referred to, yes.
And in your testimony, you felt it was important to point out to this jury that your interpretation of the sock graph showed the full daughter spectrum on July 24th. Isn't that true?
At that point, yes, after a conference with Dr. Martz.
And Dr. Martz, you mean Agent Martz? Agent Martz?
Agent Martz, right, I'm sorry.
And did you see Agent Martz testify on television, or did you read his testimony in transcript form?
Both.
And you also, of course, heard his opinion that the substance that was detected in the gate and the sock stain and in his blood may be consistent with the EDTA, but could not be so identified, correct?
That's what he said, yes.
And he said that because he felt that it would be inappropriate We're all doing it.
We're getting it.
He said that because he felt it would be inappropriate to say that the EDTA substance was identified unless the full daughter spectrum was present. Isn't that true?
Pretty much, yes.
Now, sir, when you indicated previously that you could not account for the results shown in Agent Martz's own unpreserved blood, after you received those results on Agent Martz's blood, what effort did you make to perform any tests on, say, your own blood to see if it came out with the same results as Agent Martz?
I didn't make any such effort. It wasn't in a contest of whose blood is better or anything. That's not, I didn't do any experiments. You know that.
Sorry?
I've told you before, I didn't do any experiments at all.
The answer is then none. You
That's
did
what
no
I...
experiments.
Again, yes, I didn't perform any experiments.
And you've indicated to counsel on direct that there was a method by which you could quantify the amount of blood in a sample in order to be very precise about the amount that there is in there, correct?
It's very easy to quantify the blood, yes.
Now, you actually had bloodstains 47, 50, and 78 from this case.
Objection. I'd like to approach.
All right, with court reporter, please. Thank you, counsel. Proceed. Mr. Blazier.
Ladies and gentlemen, good afternoon. Dr. Ritos, good afternoon.
Good afternoon.
How are you feeling today, doctor?
I'm afraid I'm terribly irritable. This bronchitis and all has made me quite irritable. I'm sorry if I got carried away by it.
Has Ms. Clark's questions made you feel any better?
Make fun?
Has Ms. Clark's questions made you feel any better?
After lunch, I felt better.
Sustained.
Dr. Ritos, I want to just ask you a few questions about the sconce matter. Were you the only forensic toxicologist to find oleander in that tissue?
No,
Were you even the first one?
no.
Who was the first one?
Dr. Randy Baselt of the Institute of Chemical Toxicology outside of San Francisco.
And is he a very highly respected forensic toxicologist?
Yes.
Now, Dr. Henyon, is he a highly respected forensic toxicologist?
He's really not a forensic toxicologist. He hates to go to court, so
Now, in stating the opinions that you've stated here today about the sconce matter, have you relied on Dr. Henyon's report in the sconce matter?
Did I rely on it? No, not at
In
all.
terms of the opinions that you stated today about what he did versus what you did?
Well, I relied on what he wrote in his report.
What aspect of his report did you rely on?
The entire report, I relied on the list of specimens that he has in it that he sent to California or Ventura. I relied on his own statement in there that what he did didn't in any way, shape, or form have a bearing on what was in there when this man died years earlier.
And are you referring to a specific part of his report that you relied on?
Well, you mean this
Specific
report?
sentence?
Yes, yes.
Could you read that, please?
Sure, be glad to.
What page are you referring to, Mr. Blazier?
I think it's page
Sir,
one of
this
the
is
report.
the first page after the cover.
All right.
It is in the introduction.
Yeah.
If you don't have a copy, I can read the whole thing, but really this is the relevant portion, right? Well, let me read the whole paragraph.
Objection, Your Honor. I think that the witness should be able to read it to him. I'd like to see it.
Oh, I'm sorry. I thought you had a copy.
Objection, irrelevant.
Oh,
Can I show the court?
if the objections is relevance, that objection's overruled.
Could you please read that paragraph that you relied on?
I'd ask the witness read it to himself and indicate. It was to refresh his recollection, Your Honor, wasn't it?
No, he was asked what he relied upon.
Objection, hearsay.
Sustained.
Anything that Dr. Henyon concluded caused you to change your opinion in any way?
No, not at all.
Incidentally, after you finished working on the sconce matter, did the Los Angeles District Attorney's Office hire you to work on another case?
I was already working on one, and I worked on another one afterwards, yes.
And what case was that?
Dr. Boggs.
Now, I want to ask you a couple of questions about the differences between what Agent Martz has testified to and what you have testified to with respect to whether or not this is EDTA that's on the gate and the sock. Do you have that in mind?
Yes.
Is it accurate that both of you agree that the retention time that he got is consistent with EDTA?
Yes.
That the presence of the parent ion, the 293 parent ion that he found, is consistent with the presence of EDTA?
Yes.
The presence of the 160 daughter ion that he found, do you agree is consistent with the presence of EDTA?
Yes.
And he agreed with that, did he not?
Yes.
Would you agree that the only difference between your opinion and his opinion is based on his inability to find the other piece, the other daughter ion, the 132 daughter ion?
Objection, reading.
Sustained. Rephrase the question.
So your understanding, what's your understanding with respect to Agent Martz's unwillingness to declare that what he saw was EDTA?
That he performed one analysis where he scanned widely between 130 and 293 across the spectrum for both daughter ions, and he claimed that in that he didn't see anything. Didn't see the 132 daughter ion, that there was nothing there because the computer didn't print out any numbers.
Now, this machinery that he has,
Overruled.
the machinery that he has, you recall that we were talking before about the analogy of a television camera that's set up to focus on you and maybe scan back and forth, but not deviate very much from where you're sitting. Remember that analogy?
Yes.
And that's the analogy that relates to looking for the 160 daughter ion, correct?
Looking either at the 160 daughter ion or scanning across and seeing where it appears in that scan.
And when Agent Martz did that scan of the 160 ion, the small range 158 to 162, he found the 160 daughter ion, didn't he?
Yes.
Now, does that machinery that he has, that the FBI has at their lab, is it capable of also looking at the 132 ion?
Yes.
Is it capable of scanning that area within a small range?
Yes.
Did he ever do that?
He said he did not.
Now, did you hear Ms. Clark's questions about whether it's incumbent upon a scientist to do every possible test available to test a hypothesis?
I remember the question, yes.
Did Agent Martz do every possible test available to try and see whether or not the 132 ion was there?
No.
Now, you indicated that Agent Martz did one test that provided some information about whether or not EDTA on a metal can might be lost by virtue of it being on a metal surface. Remember that?
Yes.
What were you talking about? What were you talking about when you referred to that?
He put some EDTA blood on a metal can surface and also on a control swatch. Then he wiped the surface subsequently, so he had a swatch from the surface and he had a control swatch, and he analyzed both.
Sustained. Rephrase the question.
Did you review Agent Martz's testimony?
Yes.
Did you read it and look at it on videotape?
Yes.
Did you hear his discussion about his test results with respect to the amount of EDTA he got off of his metal can versus the cloth swatch?
Yes.
And what's your understanding of that testimony?
That he found EDTA in both. There was less in the one from the can than on the control swatch.
And scientifically, what inference can be drawn from that?
Well, one obvious inference is that he got less back than what he put on the can, so some of it was broken down by the can, swallowed by the can, or otherwise. But the likely thing is destroyed, broken down, altered.
Would it be fair to characterize Agent Martz's testimony with respect to quantity that his opinion is that he didn't find enough of whatever it was that he found that it could have come from a purple top tube? That he didn't find as much as he would have expected to find?
In my direct, I already answered that. He had no clue as to how much he started with in his samples. So how could he determine what the concentration was? He could only apply amounts. If you don't know what the concentration is, you don't know what you're dealing with. So there was EDTA in the blood, and if it was a tiny, tiny amount and the concentration was the same in an EDTA tube, he doesn't know what the concentration was.
Did he do any experimentation or anything as a result of you watching his testimony indicating that he tested to find out how much EDTA he would expect to find after 8 months under the conditions of which these samples were subjected to?
No.
Is that something that if you were trying to do every possible test to test a hypothesis that he should have done?
Yes, I would think so. At least partly. I mean, for a period of time, not necessarily 8 months.
Now, if Agent Martz were testing the hypothesis as to whether food or other substances can create levels of EDTA in the blood equivalent to the amount found on the gate and the sock, what would be the proper way to test that hypothesis? What would one proper way be?
To test 10 or 20 random blood samples from normal people, or as many as you can conveniently. It's a simple test, so you can test a lot. It's a standard procedure.
Do you feel that him testing his own blood after placing it in a red top tube for a period of time is an adequate test to determine how much EDTA he might have had in his blood originally?
Not without adequate quality control, such as testing red top tubes if you put things in them, whether there's any EDTA in the stopper or in the lining, in the silicone lining, which wouldn't be too unusual. You know, without that, it's not a very good way of getting an answer. Besides that, if you put blood in a red top tube, you can't test blood, you test serum or plasma.
Why is that?
Because it clots.
How long does it take to clot?
5 to 7 minutes.
You have a minute, Turner.
Fair enough.
Dr. Reeders, do you know of any other compound that would give you the retention time, the 293 and the 160 ions, as EDTA does?
I don't know of any, and I have not found of any. I've specifically searched not the Merck Index, as was mentioned, but there's a separate Merck Index publication which lists molecular weights. And by looking at those substances that have a molecular weight of 292, and then looking at their structure, I mean, you know, there wasn't anything in there that indicated that I could get a 160 or a 132 ion out of those in a mass spectrometer. I also looked in an index of mass spectra that I have and didn't find anything in there that matches this particular pattern.
Now, you can't say, since you haven't looked at all 11 million or how many ever organic compounds there are, you can't say whether there might not be some other compound out there that hasn't been looked at that might look like this, correct?
That's correct. That's always true. I've said that before. You can only work with what you know.
And that's true with any kind of substance that you're looking for, that you're examining with mass spectrometry, correct?
And any
Sustained. Sustained.
Is that true with respect to any compound that you look for with mass spectrometry?
yeah, and any test, any
Now-
form of mass spectrometry. You can't give an absolute answer. You cannot identify something to the exclusion of all other compounds unless you do it purely by faith alone.
Now, we've been talking about tandem MS or MS-MS in this case. Why is it, why do you repeat MS and then repeat it again? What does that mean?
Well, the technique is a little bit different. I think I explained what MS is. I think maybe Roger Martz did too, about weighing a molecule, breaking it up like a diamond, and then weighing the pieces. In MS, what you do is you put the material into a mass spectrometer. It weighs it, and then it takes preferably the whole molecule, or the whole molecule with a charge on it, a hydrogen ion charge, and filters it into another mass spectrometer alone, all by its lonesome, without all the other junk that's sitting back there. So you've isolated that particular ion. Then that second mass spectrometer cuts that into what's called daughter ions, into 2 pieces, perhaps 3 pieces. It's called by colliding with gas molecules. That's how it's done, gently. And then it weighs those pieces. So that is the second mass spectrometer. The better way is to take it into the second mass spectrometer, then break it up, and then again filter out one of the ions into a third mass spectrometer for measurement. That's what you have when you have MS. You can continue that virtually ad infinitum, not with his instrument, but with some instruments. So you can go to the 5th mass spectrometry.
Is it accurate to describe then that the first MS is looking for the parent ion, the 293, and the second MS looks at the daughter ions?
The first MS looks at the parent ion. The second MS takes that parent ion purely and breaks it up. And the third MS measures it.
Now, are tests done to determine identification of substances using just MS?
Of course, they've been done for a long time. As a matter of fact, that is a widespread standard.
And did we
this
have,
technique is a relatively recent one.
when MS was designed, did we also have MS-MS, or did that come along later?
Afterwards, not terribly long in research form, but it came afterwards.
Is it accurate to say that testing is done all the time where identifications of substances are made based on just MS?
Yes.
Doctor, after being cross-examined and hearing Agent Martz's testimony, do you stand by your opinion that what was found on the back gate and the sock to a reasonable degree of scientific certainty was EDTA?
Yes.
Do you stand by your opinion that the probable source for that EDTA was a purple top tube?
Objection, that mistake concluded.
Well, probably yes.
Do you know of any other possible source for that amount of EDTA?
Yes, theoretically.
Any other source that you would expect to find in someone's human blood?
If they have been treated with intravenous calcium EDTA within the last 8 hours for lead poisoning, yes.
Other than that?
Or for other forms of treatment, diagnostic or treatment with disodium calcium EDTA.
How about just after normal diet?
No way.
That's all I have.
Ms. Clark?
You mean the readings that Agent Martz obtained in his unpreserved blood, there is no way that those could result from him having a normal diet in which he ingested food that contained the preservative EDTA?
In my opinion, that's correct. It's no way.
So the result that he got is not there. It's unreal. Is that right?
No,
Oral.
no, I didn't say the result that he got isn't there. It's there on paper. How it got there is the question of what's its source.
What are you trying to infer, Dr. Readers? Are you trying to tell us that you think he added EDTA to his own blood?
I didn't say that, you did. I said, I don't know what the source is. It could be contamination, it could be a mix-up. I seriously doubt that he would add it to it. He's an honest man. He's not a crook. But there are any number of ways that this can happen.
And then one way that you've just mentioned was through the possible presence of EDTA in a red top tube. Is that one way you just mentioned?
That's a possibility. He never checked it out, so it's not ruled out. So that's a possibility.
Well, Dr. Readers, did you ever check it out? Did you ever run any tests on a red top tube to determine whether there were trace amounts of EDTA contained in it?
Sustained.
On a red top tube?
He asked if he did any experiments whatsoever, and the answer was no.
Doctor, you indicated, you talked a little bit about concentration with counsel. If EDTA is assumed to be present in the evidence and in the reference to blood, and you wanted to prove that the blood on the gate and the sock came from preserved blood, as a scientist, wouldn't it be logical to conclude that the concentration should be the same in the evidence and in the reference blood?
If they are both fresh, yes. If one has been sitting on a fence for various periods of time, wouldn't have to be the same. What I was mainly saying is that you have no clue as to what the concentration is because you never measured how much blood you have.
All right. But then you could, as a scientist, test that hypothesis by doing tests to quantify precisely the amount of blood so you could determine exactly whether the concentration was the same, could you not?
Oral.
Yes, I said that's what you can do. In my direct, I even said how to do it.
Now, Dr. Readers, if you, as a scientist, wanted to affirmatively prove the presence of EDTA in evidence stains, you could conduct exactly that form of testing, could you not?
Well, I could conduct it, but I wanted to prove exactly or approximately. Of course, one can do those tests. That's why I proposed them. They are not tests that can't be done.
And did you propose that such testing be done on the evidence in this case to counsel, defense counsel?
Sustained.
All right, Dr. Readers, you indicated that you relied on Dr. Henyon's report with respect to what tissues he tested. Is that correct?
I'm sorry, where are we now?
We're in Wisconsin.
Oh.
You
yeah,
indicate...
I relied on his report as to what tissues he tested, sure, because that's what he reported as having received and tested. I also relied on Dr. Lovell's letter stating what tissues he sent.
All right. And then it's your position that based on your review of that report, that he never tested the tissues taken from the 1985 autopsy. Is that correct?
Yes, that's correct. He says so himself.
Would you change your opinion, Dr. Readers, if I were to show you a videotape of autopsy tissues being delivered to the defense toxicologist Brian Finkel?
No. What's that got to do with it?
May we approach?
Nope. He said no, wouldn't change his opinion. Proceed.
In other words, if you were to be,
No. Sidebar with the court reporter. Gentlemen, would you just step back real quick into the jury room? I need to take a look at something. Well, before we do that, the report of Dr. Henyon that you've given to me and directed my attention to page 5, samples 001 to 007, that appears to be from the 91 exhumation, correct?
yes, that indicates that some of the tissues delivered, and there's no dispute that exhumation tissues were in fact delivered to Dr. Henry. There's no
All right.
question.
Those are the only samples.
No, not.
In the report, it's the only ones in the report.
All right, in the report, is there reference to any samples from the original autopsy?
In whose report? In Dr. Henyon's report?
Yes. I mean, what is the basis for you asking these questions?
Because on redirect, the witness was asked.
No. I'm asking within the reports that you have, where's the contradiction?
No, that wasn't the point, Your Honor. Counsel asked Dr. Reeders whether, I think the witness ought to be excluded for this. I really do. Counsel asked Dr. Reeders whether reading the report refreshed his recollection as to whether Dr. Henyon got 85 autopsy samples or not. He indicated yes. He indicated that looking at the report, he was able to confirm the fact that Dr. Henyon never got 85 autopsy samples, and that's what I asked him.
All right.
I went back over that. I said, how does this report indicate to you that he did not get the 85 autopsy samples?
And that's what you propose to ask at this point?
No, I already, I went back.
Or do you ask him what tissues were tested?
Here's my question. Then it's your position that based on your review of that report, that he never tested the tissues taken from 1985 autopsy, is that correct? Answer, yes, that's correct. He says so himself. Then I asked, did you change your opinion? So it is Dr. Reeder's testimony that the review of this report confirms his opinion that Dr. Henyon never got 85 autopsy samples.
No, he wasn't there when this was done. He has Dr. Henyon's report. Dr. Henyon's report said, I got this stuff in 1991. Dr. Lovell's report says, I was there when we got it from the mausoleum. It looked like mud. This is completely improper. I tried to raise this initially. I think the whole line of questioning is improper. I asked the jury be admonished to disregard everything about sconce as being completely irrelevant and done in bad faith. There's nothing in this report indicating that he tested anything other than what Dr. Reeder said he tested. What Dr. Reeder said is based on Henyon's report. That's all he has.
You know, my God, this is reality standing on its head. It's absolutely clear. If you look at the videotape, Your Honor, we have all the memos from Brian Finkel. We have all the letters that indicate that he absolutely did get and test 85 autopsy tissues. There's no question about this. I don't think, perhaps counsel doesn't know.
That he Henyon or he Finkel?
He Finkel and he Henyon, both. Finkel hand-delivered samples to Dr. Henyon, and some of the samples that he hand-delivered were, in fact, 85 autopsy tissues that were given to him.
All right, where do we have that documented?
Well, where do we have that? You're talking about in this report?
Anywhere.
I'm not the one who asserted that this report was competent material to refresh this witness's recollection. That's what counsel used. I contend otherwise, and that's why I wanted to show him the videotape, because there was no way from this report that he could possibly have reaffirmed his position that there were no autopsy tissues given to him, because the manner in which it's documented here is insufficient for him to say one way or another, and yet he has. He has said that based on this report, he can say he never got autopsy tissues from 1985. That he can't do that. And he's formed an opinion based on something he cannot, that doesn't give him the information he claims it does. I have something that will give him that information, and I want to confront the witness with it. And I think that on cross-examination, it's certainly fair game to do so.
All right. You're saying that he's used something to refresh his recollection that you say is an insufficient basis for him to have refreshed his recollection, therefore you're entitled to cross-examine on some videotape? Is that what you're saying?
No, I'm challenging the basis of his opinion. I'm challenging, first of all, the opinion itself, but also the basis of it. Number one, the report can't possibly be used as a basis for him to conclude that there was no 85 autopsy tissue given. Secondly, would it change his opinion, and certainly I'm entitled to do that, Your Honor, with an expert, would it change your opinion, doctor, if you were to see this videotape?
Which does what?
Which shows the tissues being cut and split to give to Dr. Hinkle, who was working with Dr. Henyon on this case for the defense. This is a 1-minute videotape.
One, I don't think that proves anything. Let's assume it's true. Dr. Readers wasn't there for this. It can't refresh his recollection. It's not in Dr. Henyon's report. Dr. Readers has testified that that's what he has, is Henyon's reports, which says, this is what I tested, and it's from the 91 exhumation. Nothing in there about testing anything else. It's reasonable for him to say, this is his report, this is what he tested, so he probably didn't test anything else. That's not impeachment.
Your Honor, this witness has stated in categoric terms, very definitely, that the 1985 autopsy tissues were never sent for Dr. Henyon to test. He's been very emphatic in his testimony about that, Your Honor. You know, and now we're going to backpedal a little bit and try and pretend that didn't happen. It did happen. And we have the right to challenge that opinion because it's fundamental to the discrepancy in their results. And Dr. Readers knows that.
I would like to make a discovery request on anything they have that shows that Dr. Henyon, in a report, tested something other than the report we have. If there's another report, we should be entitled to see it. As well as anything that shows that Dr. Readers would know something that Dr. Henyon did that's not in his report.
And, Your Honor, let me point out something in Dr. Henyon's report as well. There is a listing you can see in the key where it talks about the tissue samples are with tissue samples provided from Dr. Readers via Federal Express. Right? That's on page 5.
Page 5.
At the bottom of the page, it says samples 1 to 7, delivered by Federal Express from Dr. Reader's laboratory. Okay?
Wait, at the bottom,
At the very bottom.
on page 5.
Yes. Samples from 001 to 007.
All right, my copy here says samples 001 to 007 hand delivered by Dr. Finkel.
It works.
Well,
You showed
maybe
the
that's
report.
why I'm having a problem here.
Yeah. At the bottom, it shows 001 to 007 as specimens sent from Dr. Reader's laboratory via Federal Express. If you will look at the listings above that on page 5, Your Honor, you will see that there are R008 through R0016, which indicate other samples recovered from Dr. Reader's. And I really think that the witness should be excluded for this, but
All right, looking at page 5 of what you've just given to me, would you direct my attention where it talks about 001 to 007 being 85 autopsy samples?
I'm not saying that it does. It's actually R008 through R0016. You see, what occurred is that Dr. Henyon got a split of Dr. Reader's tissues. He also got, however, autopsy tissues that had been maintained by the coroner at the time of the exhumation. In other words, in 85, there were tissues removed from the body. Some were kept at the coroner's office, some were given to Randy Bassell, who later forwarded them to Dr. Reader's. Of the tissues that were maintained in a preservative at the coroner's lab, Dr. Finkel was given a split of those, and by Dr. Lovell, and that's what's documented in the videotape. So, and he took those to Dr. Henyon, and in addition to that, some of the frozen tissue samples that Dr. Readers had from the 85 autopsy were also forwarded to Dr. Henyon. And Dr. Finkel and Dr. Henyon have records that will verify that. I also have a letter to Dr. Henyon from Roger John Diamond, in which it indicates that the defense wishes to retest the same materials which the prosecution expert tested. And of course that makes sense, because how are they going to convince the people to dismiss a case unless they make sure that they do test the same tissues? Otherwise, the people have the very argument that Dr. Readers is trying to proffer, which we know is untrue.
All right, Dr. Readers, why don't you step out of the courtroom, please? Why don't you step out of the courtroom, please? Thank you. Well, we got two different reports here, that's for sure.
Maybe you provided with copies of both. That's our only copy.
All right, let me see this videotape.
Sound on? Level is transferring to Dr. Finkel the tissue from Timothy Waters from the autopsy in 1985. But the jar that Ventura Corner kept had all of the tissue together in one jar. And he's now giving it to Dr. Finkel. And these other 6 plastic jars are the jars from today's autopsy. They're not even labeled yet.
Those are the same ones that you have that are labeled. Right. Okay.
Actually, the first minute is sufficient because it's identified as being narrated. We can freeze frame onto the jar itself that shows the coroner's number and the date of the autopsy, 1985, so that it's clear that on that jar there are 85 autopsy tissues. We don't need that last time.
It's not proper authentication. Let's assume it was, however. He's already said this is not going to refresh his memory about anything because he wasn't there. It'd be completely improper to show it in front of the jury to this witness who's already said his memory is not going to be refreshed. We want to bring him in, let him watch this. Then you can ask him again, but he's already said it's not going to refresh his memory. I still want to see Dr. Hinyon's report of testing on those tissue samples. I've never seen it. I don't think it's in the, it's certainly not in the one that I had. I don't think it's in hers.
It is in mine, Your Honor. The question.
All right, we'll take a recess. You can show Dr. Readers the tape. Show counsel where Dr. Henyon mentions testing the 85 autopsy.
But, Your Honor, he doesn't say it's 85 autopsy tissues. He does it by number.
I understand that. I understand that.
And I'm not asking to refresh his memory. I'm asking to show him something before the jury to see whether or not it will change his opinion any. And I cannot believe.
Well, I got to tell you, this is an incredible amount of sidetracking on a collateral issue on a non-case. All right, we'll take 15. Doesn't matter, all parties are again present. Ms. Clark, Mr. Blazier, have you had the opportunity to compare your reports?
Yes, Your Honor, and I've determined what the source of the discrepancy is. The defense and the prosecution joined in a desire to, I thought the witness was excluded.
He is. Ms. Clark.
Yes, Your Honor. In that case, the defense and the prosecution both sought to retest the tissues. Obviously, the defense desiring to preclude the kind of argument proffered by Dr. Readers that their tissue was simply older, and that explains the lack of oleandrin, the defense requested that they retest the same tissue. The prosecution also requested the same retesting, and they independently submitted samples to Dr. Henyon. And so you have two separate reports generated, one to the defense, one to the prosecution. And each of them submitted their own samples. Now, Dr. Readers, I proposed two things. What you can see in one of the reports is that there were samples delivered by Dr. Readers via Federal Express from his lab. In the other report, you have Dr. Finkel. The difference being that Dr. Finkel hand-carried some of the samples, and Dr. Readers, via Federal Express, mailed some of the samples. And one went to the prosecution and one went to the one came from the prosecution, one came from the defense. Hence the difference in the listing of samples tested in the two different reports. That's that. Dr. Readers has, I propose to show him a bill which indicates that there was a shipment of specimens to Dr. Henyon, and that was this bill is dated for 1991. He's billing for the expense of shipment of those specimens. Because the billing entry is ambiguous, we asked that Mr. Blazier have Dr. Readers bring in his file with the chain of custody documents, and we were told to pound sand. So we are now going to request of Dr. Readers that he examine his file for the chain of custody documents to indicate the tissue samples that he did surrender. We do know that he did surrender frozen tissue samples that he had from the 85 autopsy to Dr. Henyon, in addition to which Dr. Lovell gave...
Why don't you just ask him that?
I will, but I believe that he doesn't have them.
No, why don't you just ask him, did you give the 85 samples that you had still in your custody to Dr. Henyon for testing with regards to this case?
I believe that I did, Your Honor. He said that he offered it, but it was rejected. That was his testimony.
All right, so what is this bill going to show us?
Well, he shipped tissues. It may indeed impeach him. He shipped tissues to Dr. Henyon.
How do we know it's the 85 tissue?
Why would you ship only the exhumation tissues if you have both in your possession?
You're right. Sorry.
I mean, it doesn't make any logical sense that he would do that, especially when we have letters from Roger Diamond, the defense attorney, indicating that he desired to retest the same tissues for the obvious logical reason that if he doesn't, the people will not be convinced to dismiss the case, which is in fact what happened. So That's why there were two ways that Dr. Henyon got the 85 autopsy samples. From a very simple and broad-based point of view, Your Honor, this witness has attempted to represent to the jury that the only reason there were negative results by Dr. Henyon is because he never tested 85 autopsy tissues, whether they came from him or someone else. He has denied categorically, based on his review of everything he has seen, that Dr. Henyon ever tested such tissues from the 85 autopsy. A very simple impeachment method is to say, look at this. Does that change your opinion?
Did you show it to him over the,
Yes, I did.
and during the break?
The video?
Yes.
Yes.
I thought
Yeah.
you meant the receipt.
Break.
The
All right.
video was shown to him.
Yeah, he
yes.
did. He has no
Well, he
idea what it
didn't
is.
refresh his recollection. Of course it wouldn't refresh his recollection. That's not why it's being shown. It's being shown to see if it will change his opinion as to whether Dr. Henyon received 85 autopsy tissues for testing. His answer either way is going to be illustrative, and it's one
And you're
question.
and you're going to bring in Dr. Henyon at some point to say, I tested the 85 autopsy stuff, and it's included in my report as sample R something.
That's right.
Dr.
That's right.
Henyon-
Actually, two different autopsy samples, one from Dr. Reeder's and one from the cutting made by Dr. Lovell in 1991.
All right, so haven't you already asked and established the negative answers?
No, not with respect to this. And I think it is germane to, this is cross-examination, and the witness's refusal to accept an obvious fact in order to change his opinion, or if he does, to change his opinion, is clearly relevant to his credibility. It's one question and a 1-minute video to demonstrate graphically that it doesn't matter what this witness has shown. He's never going to change his opinion. And I think that's highly relevant to his competence and his credibility, which the jury has to assess.
Mr. Blazer?
Collateral. It's incredible. Now I have two reports that look the same on the surface, but they're different. And the reason they're different is because some tests are included in one that aren't included in the other. The one that Dr. Reeders has is he got one report. He didn't get both reports. This is outrageous. I think if we're going to go into this at all, he needs an opportunity to at least see the second report that was not sent to him. This is so confusing. I can't tell what's in one and what's in the other now. They look the same when you look at them, but when you start comparing samples, they're different.
Well, the same conclusion.
Yeah, the same conclusion is that the absence of these analytes at the time of the analysis does not mean they were not present at an earlier time. Little is known about the chemical or enzymatic stability of these substances over time under the conditions of storage experienced by these samples. So regardless of what's included in both of these reports, he comes to the same conclusion. That is, he can't say that Reeders was wrong.
I disagree with counsel's characterization. There is a qualification issued by Dr. Henyon, but we come to a larger issue then. Really, had Dr. Reeders known of the appropriate and most sophisticated method of testing back when he did the testing in 1988, it would have been better confirmed or refuted that the presence of oleandrin was there, that there was oleandrin present in the tissues. His failure to know of the most appropriate testing.
But we've already talked about that.
Okay, nevertheless, all I'm asking
The
you to do...
only issue then here is whether or not Dr. Henyon tested the 85 autopsy specimens. That's correct. You've already asked him that. He said to his knowledge, no, he didn't. Correct?
He's done more than to say to his knowledge, no. He is saying no categorically, he did not.
All right, and you're going to bring in Dr. Henyon.
Yes.
Okay.
So the court, the people have some very graphic evidence that takes no time to confront the witness with to see if he will change his opinion.
That's probably one of the worst videotapes I've ever seen. I mean, I've seen 9-year-old kids take better videotapes than that.
Well,
I mean, it's going all over the place. You can't tell what it is. It doesn't focus in on a date and time.
yes,
I mean,
it can be freeze framed to show that this is autopsy tissue, and it's narrated. Your Honor, I didn't make this videotape.
Obliquely. But see, this is such a collateral issue. If you've established already that he says he didn't have the 85 autopsy, that the 85 autopsy samples were not considered by Dr. Henyon, and Dr. Henyon comes in and says, yes, I did have the 85. I came to a contrary conclusion than Dr. Reeders. I disagree with, his professional opinion. Well, that's the point. And you don't need to show this. And if you've shown it to him and it doesn't refresh his recollection, then there's no basis to show it. I'll allow you some leeway, and I have to tell you, this is an incredibly confused situation to now have two of these technical reports which appear on the surface to be identical, but if you look at them carefully, they talk about different things at different points at different times. Maybe it's because I'm tired and it's been a long day, but I'm completely confused reading these two reports. Because they're not the same reports and they say different things. So
Well-
at this point, you can ask, just restate that to set where we are, that Henyon, in his opinion, Henyon didn't test the 85 samples. That's the end of the inquiry. I find the videotape, since Dr. Readers has already seen it, doesn't refresh his recollection as to what it is. I'll sustain the objection at this time.
May I show him his bill?
You can see if that refreshes his recollection. All right, let's have the jury, please.
Description to the jury of what it is.
No, I don't think that's appropriate because the jury needs to know what it is that's being presented. And if it does or does not refresh his recollection. Here's the billing. Do you recognize it? Does that refresh your recollection as to what was sent? That's what can be asked.
The report.
No, I think we've already established that. You've asked the question.
No. That was the defense report. There is the other report.
All right? You can ask if he's seen that other report. Ms. Clark.
I have a document, Your Honor. It has to be marked People's Next in Order 586,
587, I believe.
587. Yeah, I'm showing you what's now been marked as People's 587. Do you recognize the letterhead?
Yes,
That's your letterhead, sir?
the company letterhead.
Okay, let's see. If I may.
No. No.
Before the foundation. Is this a bill that you submitted to the prosecution for your work in the sconce case, sir?
I haven't looked at it. Let me look at it. I just looked at the letterhead. That's a bill. Yes.
Is this the bill that you presented to the prosecution for your work in the sconce case?
I really don't know. The company did, evidently. I didn't.
It says to Mr. Harvey Gist, Deputy District Attorney. Is that correct?
Right.
And it says 4 professional services, Ray Timothy Waters, David Sconce, accused, correct?
Oh. Right, that's what it says.
All right, does that seem to be then a bill for the services you rendered on the Sconce case to the prosecution?
Yes.
Now, dropping down to the last paragraph where it is circled in black, do you see a reference there to the examination, securing, storage, and shipment to Dr. Henyon?
Yes.
Does that refresh your recollection, sir?
Absolutely
as to
not.
what tissue samples you sent to Dr. Henyon?
Absolutely not. The only thing that I can surmise is that the samples that Dr. Lovell sent to me, I forwarded to Jack Henyon, but I have no recollection of this at all. It may have been done by my secretary for all I know.
Then is it your testimony that this is a reference to the exhumation tissues that were removed from the body at 1991?
Oh. I have no idea what this is. I think that it could be that Dr. Lovell shipped to me his half, and I shipped it on to Henyon, or my secretary did.
His
But
half of what, sir?
whatever was taken at that autopsy,
At the autopsy
at the
in
second
91?
autopsy in 91, yeah.
But in your opinion, this does not reflect the shipment by you of tissues that you had from the 85 autopsy?
Absolutely not. I was strictly informed not to ship anything of my own specimen. I think I still have it in the freezer.
Doctor, was it asked of you pursuant to a letter written by the prosecution in this case to bring with you to court today your chain of custody documents that reflected the movement of the tissues you had from the 85 autopsy?
Sustained.
Do you have in your possession today a copy of your chain of custody documents that indicate the movement of the tissues that you received from the 85 autopsy on Timothy Waters?
Up to point, yes. Up to July 88, not July 88. Hold on. Yeah, July 88.
And July
That's on
88, I'm sorry?
That's on one of the sheets, yeah.
July 88 is when you concluded your testing, is that right?
That's, yeah, just about. After that, they stayed in the freezer. That's all I have.
So you have no documents to indicate what occurred to those tissues after you completed your testing?
Yeah, they went into the freezer and stayed there. I think they're still in there.
That's your testimony?
They went into the freezer and stayed there. Yeah, I took him out when Mr. Diamond came to show him to him. He wanted to see them. That's all I recall. After that, I don't recall ever getting back to them, except that when we moved the freezer, I saw him still in there, which was maybe months later.
Do you recall Dr. Brian Finkel, the defense toxicologist, sir, approaching you to get a split of your autopsy tissues?
In Anaheim, yes.
And do you recall...
Not reproaching me, I approached him. He approached me to look at my tests, and I told him, do you want some of what I have? That's what.
So do you recall him asking you for a split of your tissues and you refusing to give them because you were precluded under Pennsylvania law? Do you recall that, sir?
Absolutely not. That's untrue.
And so if he so testified, he would be mistaken. Is that your testimony?
I said it's untrue. But if he so testified, then he's very much mistaken.
Let me show you. I'd like to mark that People's 580, another report by Dr. Henyon, entitled Final Report from the Analysis of T. Waters Tissue Samples Submitted by the Prosecution, People versus Wisconsin.
So, Mark.
Directing your attention, sir, to page 5, in which it indicates tissue samples provided.
It's hearsay.
It is at this point, Foundation Counsel, using this to refresh his recollection.
Yes.
All right. Why don't you review that briefly, Doctor?
I'm asking you to review the legend.
I'm not going to review the whole thing.
May I look at the whole?
Sure.
While he's doing that, let me see counsel at the sidebar without the report.
I reviewed it.
Do you see your name mentioned?
Yes.
Does that help to refresh your memory as to whether or not you mailed or sent Dr. Henyon some of your 1985 autopsy tissues?
No, it does not. May I see my own report that I gave you a while before? This is different from my report. This is a change report.
No. Sir, are you aware that there were 2 reports prepared by Dr. Henyon in that case? One for the defense and one for the prosecution?
Yeah.
Did you know that?
No, I didn't know that. How would I know that? I got my report from Harvey Giz. That's all I know.
Mm-hmm. Do you see an entry on your bill that's still in front of you on the witness stand, sir, that indicates that you had conversations with the coroner, Dr. Lovell, pre- and post-exhumation?
Yes, I see that.
During the course of those conversations, you were informed, were you not, that both the prosecution and the defense were requesting retesting by Dr. Henyon?
Hearsay.
Sustained.
Did you discuss with Dr. Lovell the reason for the exhumation in 1991?
As I recall, I told him what I understood was the reason for all of this taking place. Yes.
And what did you understand was the reason for all this taking place?
Objection, irrelevant.
Sustained.
All right, sir, you indicated that you cannot identify any compound at any time. We're done with that, sir. You indicated that you could not identify any compound at any time to the exclusion of all others. Is that correct?
In my opinion, nobody can, and I certainly can't. I'd like to meet the one who can.
And you indicated that in order to do that, it requires faith. Is that what you just said?
Require what?
Faith.
Well, you can say you did, and that's an article of faith, but it's not an article of science, because you can only exclude it if you compare it with all other compounds in existence, which includes the ones we don't even know of. So it's absurd.
And so you have testified in this case that although you cannot say that the substance found in the gate and the sock are EDTA from preserved blood to the exclusion of all other compounds, you have indicated that in order to say that, it would be an act of faith, correct?
Argumentative.
Well, of course I can. Nobody can.
And isn't that exactly what you said in the sconce case when you claimed to have identified oleandrin?
Objection, argumentative.
Sustained.
Wasn't that the very language you used, sir, when you testified at the preliminary hearing in Sconce that you had identified the presence of oleandrin, which was later refuted by Dr. Henyon?
Objection, irrelevant. Misstates the testimony.
Sustained.
Nothing further. Doctor, thank you.
All right, thank you very much, Doctor. You may step down.
Thank you.
All right, next witness. All right. Do we have the witness available? All right, let me ask the jury to step back into the jury room for just a moment. All right, record should reflect the jury is withdrawn from the courtroom. All right, next witness by the defense is Michelle Kessler, correct?
That's correct, Your Honor.
All right, Mr. Goldberg, you want to state your objections at this point?
Thank you. Your Honor, we filed a brief on Michelle Kessler, and we had a number of different objections to her testimony, one of which related to the news leaks, and I think that's been dispositively resolved now, although not 100% sure, but I think so. And I think probably counsel understands that based on the court's earlier rulings, they would not be allowed to inquire, but I think we need to make sure that that is their understanding. For the record, There were several other items that were also contained in the same brief. One was that the defense should be precluded from inquiring of Michelle Kessler as to the status of her husband as having a job with robbery homicide. He works for robbery homicide, and he works in the division that investigates bank robberies. We argued in our brief that that's entirely irrelevant on the issue of this witness's bias or any other issue. The other item that we'd like to preclude is we'd like to preclude any questioning to the effect of trying to imply or suggest that Michelle Kessler has a bias to testify adversely to the defendant because of any anger towards the defense attorneys. I'm not positive that they intend to get into these areas. And perhaps if they make an offer of proof, we could discuss them at more length. Another item that we wanted to preclude was any impeachment on what we would regard to be a collateral issue. That is that at the Griffin hearing in the municipal court, Michelle Kessler testified that a certain item of evidence had been sent out for testing, or she said that it has already been sent out, is the way she phrased it. And in fact, the item, excuse me, she said it's waiting to be sent out, or it's ready to be sent out, is I think the precise language. And in fact, the item had already been sent out to Cellmark. It is not relevant to any issue in this proceeding and is therefore collateral. And then finally, Your Honor, on the issue of policy, if that is the only issue that counsel wishes to address, and I'm not sure that it is, we believe that there has been extensive testimony in this trial about the policy of the Los Angeles Police Department from a number of witnesses. Michelle Kessler is not an expert in policy. She doesn't really have any more knowledge of it than any other witness from SID.
The lab director isn't an expert in policy?
No, because the policy in terms of the Los Angeles Police Department policy manual is promulgated by uniformed police officers. And they spent a lot of time asking them about the Los Angeles Police Department policy manual, and she did not write the manual. She did not participate in writing it. So we believe that under 352 it should be excluded. I have other arguments on many of these items, but I don't know exactly which ones, if any, defense intends to get into. So on those 5 issues, the husband, policy, the impeachment on the collateral issue, involving her testimony at the Griffin hearing, any suggestion that she's angry at the defense, and the leak issue, all of those they should be precluded from questioning her about. And I don't know whether they intend to question her at all if they can't get into the leak. So without hearing from the defense, I don't have anything further to say.
All right, is she immediately available, by the way?
She's upstairs.
All right, once you have her. Mr. Farrell, is she on her way?
We sent a message. I'll ask her to come back.
All right. Mr. Neufeld?
Sure.
Ms. Kessler, would you wait outside, please? Thank you. Mr. Neufeld?
There's actually a series of different issues here. Actually, Mr. Goldberg is raising additional objections now, which were not contained in the initial papers on Ms. Kessler, and I can address that as well. It's not a problem. Let me say this: the one objection that they made in their papers was to my inquiring about Ms. Kessler regarding the leak concerning the socks. There was no application to preclude me from asking her questions about the other leaks, which turned out to be accurate and reliable. And I wanted to discuss that first because I think that's the most important issue, Your Honor. I think the issue involving the husband is, I mean, they brought out the husband on cross-examination, on redirect examination of their own witnesses. In fact, Mr. Goldberg is the lawyer himself who asked those questions. So the jury is already aware of the fact that Ms. Kessler's husband works in robbery homicide in the same unit as Van Adder and Lang. The fact that Ms. Kessler testified untruthfully, in fact, at a hearing on June 30th, when she said that items 49 and 50 were ready to be sent out in the future, and then acknowledged at the Griffin hearing later on that, in fact, she knew that they had been sent out on June 21st, 9 days before she testified in this case, I think, frankly, goes to her credibility, the fact that she was willing to lie under oath about that matter. So I think that that's plainly the kind of impeachment that is permissible under the evidence code, under any applicable case law in California that I'm aware of. But let's deal with the most important issue. The most important issue, I think, Your Honor, are the leaks. When Mr. Ullman made his argument with respect to Tracy Savage and Mr. Bosco, he mentioned about the possibility that there was not adequate security for the information contained in these reports when they came to the Los Angeles Police Department, that there may have been gossip and information may have gotten out to unauthorized personnel that way. We do not intend to make that argument with Ms. Kessler on the witness stand. That is not our contention at this time. It is our contention, Your Honor, that, and by the way, part of this comes from the 402 hearing where Ms. Kessler testified. Part of the proffer comes from an interview that Mr. Scheck and I conducted with Ms. Kessler before the city attorney at their offices a few weeks ago. And part of it comes from other testimony of other witnesses in this case. And it is simply this. On or about September 12th, the SID unit, specifically Michelle Kessler, received 2 reports. One is the Cellmark report dated dated September 8th. And the second is a report from the Federal Bureau of Investigation regarding the hair and fiber analysis results. Both those reports were received at about the same time. On September 14th and 15th, there were news stories in the Los Angeles Times and other newspapers describing both the results from the Cellmark report on the Bundy blood drops, that it was consistent with Mr. Simpson, and secondly, also summarizing the FBI hair and fiber results, saying that a hair found on Mr. Goldman's shirt was consistent with Mr. Simpson. That fact is in fact contained in that FBI report dated September 7th, 1994, but received presumably at LAPD a few days thereafter. It should be noted, by the way, that the FBI report was not received by the defense until, I believe, September 26th, which is about 11 days after it was reported in the Los Angeles Times. So you have both of those reports arriving at SID addressed to Michelle Kessler on or about the 12th. Could have been the 9th or the 10th for the FBI report, but it's very close in time. And the subject matter of both of those reports are included accurately in newspaper reports on the 14th and 15th of September. Michelle Kessler testified that those reports were kept in a secure facility. They were kept under lock and key in Mr. Matheson's office in serology. That was elicited during the 402 hearing before Your Honor, I believe, a week or two ago. And she was very, very limited as to who had authorization to those reports, because the case was being treated as a confidential case. And so the reports would not be kept in the normal routine with the serologist, but instead would be under lock and key in Mr. Matheson's office. Now, it is our argument that if individuals, perhaps not Michelle Kessler, but if other individuals had unauthorized access to those reports, those same individuals could have unauthorized access to the items of evidence. And the nexus is simply this, Your Honor. These socks were not kept under lock and key in the evidence control unit during any of the relevant time periods. Susan Brockbank testified that the socks were taken out of the evidence control unit on June 21st of 1994, and they were stored in serology. That's the same place where these reports were stored, from June 21st, 1994 until August 4th, 1994. So they were not kept in a secure fashion. Indeed, the evidence will show, and I believe Ms. Kessler will have to acknowledge it under oath, that the reports of the results were retained in a more secure way than the socks themselves were in this case. I intend to elicit that from her. I believe, Your Honor, that we are allowed to argue the inference that if the reports themselves were not sufficiently secure as to prevent unauthorized access. Because clearly there was unauthorized access because Michelle Kessler has testified that neither she nor the individuals who were allowed to have access to this report communicated with the media and were responsible for this leak. Then
Well, refresh my recollection, but didn't she also testify that after receiving those results, she communicated those results with the investigating officers in the case?
Well, as to the FBI report, we don't know anything yet because I didn't go into that during the 402 hearing, so I don't know who it was communicated to or when it was communicated to. As to the Cellmark report, she didn't know when or to which investigators the Cellmark information was communicated to. She did testify, and we do know that it wasn't communicated to the district attorney's office until the 16th of September, which was after it was disclosed and leaked to the news media. So we don't have a date on that. The one we have a date on as to who it was in fact released to was the September 21st leak. And what we know about that is that on September 20th, Greg Matheson concluded the conventional serological analysis on the ankle stain on the socks. That Michelle Kessler learned of those results also on September 20th. That together Michelle Kessler and Greg Matheson then called up the district attorney's office and communicated those results to Marsha Clark and Lisa Kahn. That same afternoon, she said she communicated that result to, I believe it's Detective Lang, but I'm not positive. I know that she did say she communicated it to some detective. So that's the circle of access with respect to the PGM results, or that there was any blood analysis done on the socks. It's a very small circle at this point. And the next day, we know that it certainly was disclosed that there was blood on the socks and that the genetic profile on that socks was consistent with Nicole Brown Simpson. So even without the last leak of information, we have two instances where the prosecution has asserted that they run a very secure facility. Remember, they made a big deal on the People's Direct case out of suggesting to the jury that we have all these mechanisms to make sure that our items of evidence are not compromised and not tampered with. And I believe we can show that that security is a farce. And the reason we can show that that security is a farce is, number one, the socks were not kept in the most secure manner at SID during the relevant time period. And two, that reports were kept in a more secure way during a critical time period. And nonetheless, it appears, or one could infer from the obvious facts, that the subject matter of those reports was leaked to the press before anyone else had access to it. 1 second. I'm sorry, I thought I made it clear, perhaps I didn't, that during the time that the socks had been removed from the evidence control unit, that is from June 21st to August 4th, they too were simply secured in the serology unit as opposed to the evidence control unit. That's the record in this case. And the reports were also in the same unit, according to Michelle Kessler's testimony at the 402 hearing. The only difference being that the reports were kept under lock and key in a file cabinet in Mr. Matheson's office, and the socks did not enjoy even that degree of security. So if we can show that unauthorized people had access to the reports, then I think that we are free to argue to the jury that if it was that kind of breach of security with regard to the reports, there could have also been a breach of security with regard to the socks. And I think that's relevant, and I don't even think that's a stretch in this instance, given the very, very compelling facts we have as to the reliability of those different leaks, the FBI leak and the Cellmark leak.
Thank you, Counsel. Goldberg?
Your Honor, perhaps before counsel sits down, he might make an offer of proof as to whether there's anything else they intend to get into other than the leak.
Well,
So we
that's what I just heard, so.
But I'm just saying so we can save time, because I don't want to address all these other issues again if counsel's going to represent to us now.
Counsel, that's the only one he addressed, so that's the only one I want to hear a response about.
I mentioned the other ones even before, Your Honor, I think in passing, but I think we're entitled to examine her on her husband briefly because they went into it, and I mentioned, I believe, her lack of truthfulness when she testified under oath at an early proceeding.
Perhaps counsel could indicate.
I heard those.
Yeah.
I heard that.
But I also made an argument about policy and whether she's angry at the defense. I'm just wondering whether counsel would offer whether he wants to get into any of these issues.
Your Honor, look, there's no question that the head of the SID can comment on policies at the SID as a director of that institution. There's also no question.
Do you
that,
feel compelled to make this argument?
No. Sorry.
Well, I see the monster lives, Your Honor. I just wanted to clarify how many monsters we were dealing with here. I don't know how many times we have to address this leak issue. We've done it now, I think, 5 times, and I don't want to spend any longer on it because the court has already ruled. I thought this was an absolute definitive dispositive ruling that finished it for all time.
No, that was only as far as Tracy Savage and Joe Bosco were concerned. So,
if the court isn't going to allow the defense to put in evidence as to what the news leak was, the court has precluded evidence as to the airing of this information, and it's not going to allow them to put that on, then how are they going to get that piece of evidence in? How are they going to prove there was a news leak? The court's already said they can't do that, and they can't put on the evidence that would be used to prove that there was a news leak.
well, in this case, they could trot in Andrea Ford and ask her what she wrote. But go ahead.
Well, yeah, or maybe many other reporters, but I would assume that if the court's not going to allow these reporters to testify to it, the court wouldn't allow some other reporter to testify to it. I hope I don't need to spend too much time on this, Your Honor, because, you've heard these arguments so many times, over and over and over again. The court has previously ruled that access to the information does not imply access to the evidence. That is a ruling that the court made. We suggest that ruling is correct. Our evidence was as to the security with respect to the evidence in this case, not with respect to any information or the reports in this case, and the two of them cannot be equated. Also, Michelle Kessler, the only thing that makes her different from many of the other witnesses that could have testified to this is that she doesn't have personal knowledge of any of these things, as was elicited in the 402 hearing. She does not have personal knowledge of when any of the reports came in, because although they were addressed to her, everything was going through Greg Matheson, and she only knows about them because of what Greg Matheson told her. So if the court just mechanistically applied the rules of evidence in this case that are set forth in the evidence code and did not allow witnesses to testify to hearsay or things to which they do not have personal knowledge, the only truthful answer that she can give when she's asked, when did this report come in, is, I don't know. Because she doesn't know other than from what Greg Matheson told her, which is hearsay. I'd also point out, and I'm not going to repeat many of the other arguments that we've previously made, that the preliminary DNA results that counsel was referring to on the 13th and the 14th, the DNA results that counsel was referring to on the 13th and the 14th were preceded by preliminary results in the form of Cellmark's cocktail. And it is also possible that the press could have inferred what the results were going to be if they knew what those preliminary results were. So trying to figure out any logical connection between the source of the leaks and any issue that is at evidence in this case with respect to the integrity of the SOX or any other piece of evidence requires us to go through so many hoops and requires us to make so many speculative inferences that I believe that the court's ruling earlier today is correct, that it is irrelevant under Evidence Code Section 350 and also should be inadmissible under Evidence Code Section 352. Let me just address some of the other issues. First of all, the question of policy, and by the way, we did address many of these things, although not all of them in our brief. Yes, Michelle Kessler can testify to certain aspects of policy, but the question is, are they relevant and should they be excluded under 352? Because we've already spent an enormous amount of time on policy, and I'd just like to quote from the Korish case, which we had in one of our earlier briefs that was filed, I believe, by Mr. Harmon, and I quoted it in one of my briefs as well. And the language there at 52 Cal 3rd, quoting from page 693, where they're talking about the admissibility of evidence of other evidence gathering techniques is, and in this case, I know the court's somewhat familiar with it, the defense wanted to put in evidence of other electrophoretic techniques that could have been used by the Los Angeles Police Department that were not used, specifically isoelectric focusing. And that was precluded by the trial court. And the Supreme Court held that we agree that it was not material to any issue in this case. The defectiveness of the evidence gathering technique in this case, if any, is not measured in comparison to other purportedly superior methods. Such a comparison cannot assist the jury in determining to what extent the method employed actually produced probative evidence, nor can it help the jury assign a weight to the evidence. So in other words, when we're trying to determine how well the evidence gathering techniques worked in this case and how probative they are, we have to look at the techniques we used, not other techniques that we could have used or purportedly superior techniques. And this is particularly instructive here because if we find a policy provision that says you could have maintained the evidence this way, or you could have collected the evidence this way, does it really tell us anything about the reliability of the technique that we actually used here? And I think, to paraphrase the Supreme Court, it does not tell us anything about the techniques that were actually used in this case to look at some purportedly different techniques that could have hypothetically been used. So I'd say that I know that maybe this is a late juncture to be arguing this because we've already gone into the questions of policy very extensively. But I'd argue that the issue of policy really doesn't tell us anything probative about what we're inquiring here. And to the extent that it is probative, its probative value is minimal and is clearly outweighed by the fact that we've already spent an enormous amount of time on it with all of our witnesses, with Dennis Fung, with Andrea Mazzola, with Greg Matheson, testifying about the policy manual, how they interpret it, what it requires, what it doesn't require, who it covers, who it doesn't cover, and that any minimum probative value that the evidence has is clearly outweighed by the fact that we've already spent an enormous amount of time and we shouldn't spend any more. Now, as to some of the other items, the issue of Michelle Kessler's husband. It was the defense that brought out the fact on cross-examination of Dennis Fung, how it came in or why it came in, I'm not sure, that Michelle Kessler is the laboratory director and that her husband works for robbery homicide. So I guess it is in the record, but we did not bring it in, and we only mentioned it after it was already brought out by the defense, and only in the context of refuting the implication that somehow Michelle Kessler and her husband, because he worked for robbery homicide, and a lot of other people were involved in a conspiracy to frame the defendant, including Dennis Fung. And that was the only context in which we asked that it be brought out. But it is irrelevant. And I think that the case of People versus Kronmeyer is somewhat instructive. And there, what happened was the defendant had embezzled, was an attorney, and he embezzled client funds from a client who was senile. And the doctor that testified as an expert witness for the prosecution that the victim was in fact incompetent was a friend of one of the beneficiaries of the victim's estate. And the California Supreme Court here at, the California Appellate Court at 189 Calap 3rd 314, and the discussion is around page 342 through 343, held that the trial court properly disallowed any questions showing the relationship between the prosecution's expert witness, the doctor, and the beneficiary of the estate. Because they said that relationship, that personal relationship between Dr. Corwin and Miller does not itself suggest any bias, and any hypothetical suggestion that a bias in favor of Miller would manifest itself further by being suggestive of Corwin's bias against anyone as to whom Miller was prejudiced is pure speculation. Well, the same exact kind of reasoning is being applied here. They're saying, well, maybe her husband's biased against the defendant because of his association with robbery homicide, and because of her association with him, maybe she's biased. I suggest that that's simply too speculative to be allowed. As to the impeachment issue on the question of her testimony at the Griffin hearing, the law is settled in California, and we've cited this in a number of different contexts, that we do not generally allow collateral impeachment. Collateral impeachment is impeachment where a witness is testifying to something that is itself not at issue in the case, and you then want to introduce evidence to prove that that testimony was incorrect. The question of when the items were actually sent out as opposed to being prepared to being sent out to Cellmark is not something that is being disputed by the parties. In other words, they're not saying that they were actually sent out on a different date than what we're saying. So the question of when they were sent out is an immaterial issue, an issue that neither side disputes and that neither side is contending is relevant to this case. So what they want to do is to ask her, when were the items sent out? And then to have her say, well, this is my understanding of when they were sent out, and then impeach her with her prior and consistent statement. So this is a classic instance of collateral impeachment, of eliciting something that is not relevant and is not admissible, except insofar as the defense wants to elicit it from the witness for the purposes of impeaching her with it. And there were quite a few cases that discussed this that we cited in our brief where similar attempts were disallowed. And essentially what these cases have said is that you really can't set up a straw man, and you can't call someone for the sole purposes of eliciting otherwise inadmissible evidence that's not in contest so that you can later on knock down that same evidence, and we suggest that they cannot do so here. It appears that what the defense wants to do is they're more interested in impeaching the witness than they are in actually getting anything substantive from her. So I guess what they want to do is call her maybe for something that perhaps the court will feel has some probative value in the case, such as policy, and say, well, the policy really isn't that you're allowed to put your evidence in plastic bags, is it, Ms. Kessler? And their officer, no, that is the policy. It's okay. You can put it in plastic bags as long as it's not for permanent storage. And then after having elicited this kind of testimony, then impeach her with the fact that her husband works for robbery homicide and this alleged prior inconsistent statement. I don't think that should be allowed. And it seems like it's a patent case of setting up a straw person. Because why would you call a witness to testify about policy who you don't think is telling the truth and then have to impeach that witness on the witness stand? I mean, there are many people that can testify about policy, many of whom are far more qualified to testify about policy than Michelle Kessler. So pick someone that you think is going to tell you the truth, rather than have her testify to something, say, well, she's obviously not telling us the truth, therefore we have to impeach her. I don't think that kind of subterfuge should be allowed by the court. And let me just say, as to this issue of collateral impeachment, Michelle Kessler does not have personal knowledge as to when the items were sent out. When she testified at the grand jury hearing, she had forgotten that she had been told previously that the item had already been sent out, and she testified that it's ready to be sent out. It's not the kind of thing that anyone would want to lie about anyway. It doesn't help the people. It doesn't help the defense. It doesn't mean anything in the context of this case. And there doesn't appear to be any material difference between having been sent out and being packaged and ready to sent out. What had happened is that the item was in fact sent out and the testing was halted. And this kind of a instance of a witness misspeaking herself on a completely collateral issue should not be allowed. So I'd respectfully submit, Your Honor, that these 5 items that I've talked about should not be permitted in evidence, and that perhaps after they've been excluded, counsel will have nothing left to ask Ms. Kessler.
All right, thank you, counsel.
I just want to clarify one thing on the leak.
Nope.
These other issues.
Nope. I've heard enough about the leak. I've heard about the leak 4 times now.
Well, it's not about the leak. What I was going to say is that we don't intend to even call reporters. I don't think we need to. I think that just with Ms. Kessler, frankly, testifying, she already testified at the 402 hearing, that she was aware of the fact that it was reported in the newspapers, that same information. And it's not hearsay because it's not being offered for the truth of the matter asserted. It's just being offered for the fact that it was in fact published in the newspapers.
All right, thank you. All right, court has dealt with this issue in a series of different guises. However, the issue is the same, whether or not this is relevant under 350 of the Evidence Code, whether or not it also involves an undue consumption of time given the very limited, almost non-existent probative value. The court sustains the relevancy objection under 350 and also under 352. Having balanced this and weighed it 3 times, 4 times, perhaps 5 times previously, that ruling stands. As to the issue of Michelle Kessler's spousal relationship to a co-worker of Detectives Van Etter and Lang, counsel may inquire into that briefly. It does present an issue of potential bias. As to the Griffin hearing, fact that Ms. Kessler gave incorrect testimony, if she in fact testifies similarly, she can be confronted with that prior inconsistent statement under oath. As to the policies and procedures of the Scientific Investigation Division, I'll allow some latitude in presentation of that testimony, since as the acting director at the time in question, as now the director of the lab, she should be familiar with the policies and procedures regarding the functioning of the SID, and that is an appropriate area of inquiry. All right, let's have the jury.
Your Honor, just one other thing. For the purposes of this examination, I would ask that the court declare her under the Evidence Code an adverse witness. I think.
Well, let's see how she answers. It's also not a civil case. All right, let's have the jury. I don't know. We may go to 5:15 just to get in a good half hour with this witness. Madam Reporter? All right. Ladies and gentlemen, please be seated. Let the record reflect we've been rejoined by all the members of our jury panel. Next witness.
Defense calls Michelle Kessler, please.
You solemnly swear that the testimony you make giving talk and opinion before this court to be the truth, the whole truth, and nothing but the truth, so help you God? I do. Please have a seat. Witness stand and state for your first and last names for the record.
Michelle Kessler, Michele Kestler.
Mr. Neufeld.
Thank you. Good afternoon. Good afternoon, Ms. Kessler.
Afternoon. Afternoon.
Ms. Kessler, what is your current title?
I'm employed by the City of Los Angeles Police Department as Chief Forensic Chemist.
And are you also the director of the Scientific Investigation Division Laboratory?
I'm the director of the Criminalistics Laboratory, yes.
Okay. And what was your title as of June 12, 1994?
I was the assistant laboratory director, or one of the assistant laboratory directors.
And could you please tell the ladies and gentlemen of the jury when your title changed?
I don't recall the exact date. I believe it was sometime in late July.
All right. So as the director of the Criminalistics Laboratory of the Los Angeles Police Department, I mean, you were Dennis Fung's boss, is that correct?
I was his ultimate superior, not immediate supervisor by any means.
And you were also the ultimate supervisor of Andrew Mazzola, is that right?
Ultimately,
And you're also the ultimate supervisor of Colin Yamauchi
yes,
and Gregory Matheson.
yes.
Now, as the laboratory director of the Criminalistics Laboratory of the Los Angeles Police Department, did you have day-to-day management responsibilities for the various units within that Criminalistics Laboratory?
I had overall management responsibility for the laboratory, not day-to-day responsibilities for day-to-day functions within the laboratories, no.
All right. And in that Criminalistics Laboratory, you would have management responsibilities for the crime scene investigation unit?
Ultimate management responsibility, again, not day-to-day.
And you would have ultimate management responsibility for the serology unit?
Yes,
And for the hair and fiber unit?
yes,
And for the DNA unit?
yes. Well, DNA and serology are all one unit, actually.
And how many criminalists were working for the Criminalistics Laboratory on June 12th of 1994, approximately?
Can't recall exactly. We had so many vacancies, probably about, I believe at that time we were down to about 40 staff members, but that's approximate.
And was another one of your responsibilities, Ms. Kessler, the evaluation of current programs and procedures in those units?
Ultimately, yes. Not day to day again, not until they're approved all the way up through the chain.
Well, and if the procedures in a particular unit were inadequate, you would have ultimate responsibility to make improvements in those units, wouldn't you?
I would suggest and listen to my supervisors, and if I personally was an expert in the field, depending on what it was, and I thought a procedure needed to be changed, I would ask for it to be changed.
But if your deputies made recommendations to you, ultimately it would be your decision whether or not to implement those changes. Is that correct?
Most of the time they made their own changes because I don't need to be involved in every small change that's made in the division.
Well, let's talk about some of the larger changes. If you introduce a new program into the Criminalistics Laboratory, and as a result of that, new procedures need to be implemented as well, would that ultimately be a decision that you would make as the manager of the, or as the director of that laboratory?
Sorry, I didn't.
You can answer the question.
Thank you. Not necessarily every small detail. Not again, no, they might review them with me, and then I would agree or disagree that we should go forth with the program.
Well, for instance, how many years ago was it that the DNA unit was introduced into the SID Criminalistics Laboratory?
Overruled.
When they started operating, doing casework, or when we started beginning to attempt to implement doing DNA or researching it?
When did you actually begin the implementation?
They began actually doing casework. I can't say when the implementation began. The actual casework began in late 1993.
And if as a result of implementing this new unit, if as a result of opening this new unit at the LAPD, it was determined that new procedures were needed, and new training, for instance, was needed, would that ultimately be a decision that you, as the director, would make?
Overruled.
Again, I think we can cover this all in one answer. Again, it's not always my decision as to who gets the training. I take the advice of my subordinates who are directly responsible for that. Now, if it comes down to a let's draw straws and see who wins, oftentimes I make that tie-breaking decision.
Now, in addition to those responsibilities, Ms. Kessler, did you also take responsibility for managing or overseeing some of the larger cases?
Not overseeing or managing, just being kept abreast of what was going on in those in larger cases at times, especially when they get out of hand, in volume, that is.
Ms. Kessler, you recall testifying at a hearing in this case on June 30th, 1994.
Sustained.
Ms. Kessler, isn't it true that you also have responsibility for managing or overseeing large cases at the SID Criminalistics Laboratory?
Objection. Vague as the time.
Overruled.
I'm not clear what you're trying to ask. You asked me this once a minute ago, and I said that I often review and not directly oversee on a day-to-day basis. Again, unless there's some reason for me to jump in and take part. It's much as the chief of police oversees anything in the department. He doesn't do it personally. So you need to be more specific what you mean.
Well, was it your practice to oversee and stay involved in the large cases?
Objection. Vague as the time.
Overruled.
No, it isn't my practice to stay involved. I like to be kept abreast of any large case and occasional rundown of what's going on in the cases. I try not to get overly involved. Stay out of the people's way.
Nope. Proceed.
On June 30th, when you testified in the hearing, were you the assistant laboratory director or were you the acting laboratory director or were you the assistant laboratory
I was
director?
the assistant laboratory director.
And as the assistant laboratory director was...
About 1994.
Yes, on June 30th, 1994. At that point in time, and by the way, were you also the assistant laboratory director on June 12th, 1994?
Yes, I was.
Okay. And at that point in time, wasn't one of your responsibilities to manage large cases?
No, I didn't manage them. I often took part in them or reviewed them, but I didn't directly manage the large cases for the most part.
Under oath, on June 30th of 1994, were you asked this question, did you give this answer? Page 18. You there? You want to read with me? Question. Tell us what that means. What are your duties? Answer.
Objection. This isn't impeachment, Charles.
Overruled.
Answer. My duties include the managing and overseeing of several areas there, including the serology DNA lab, the trace unit, and many of the other units that are there. Question. And what does that mean? What exactly do you mean by that? Answer. Well, managing also means evaluating and implementing programs such as serology and DNA, including evaluating crime scenes and managing task forces or large cases and the employees that are doing the work.
Yes.
You asked those questions, did you give those answers on June 30th?
Objection. Motion to strike. That one.
Overruled.
Yes, and that's exactly what I've been telling you here. I try not to get involved. I don't do every large
Excuse
case.
me, Your
You
Honor.
asked me if
I just asked if she was asked those questions
sorry.
and
No.
gave those answers. It's
She
not a
gets-
response. I'd move
no.
to strike.
She gets to answer and explain her answer. Proceed.
I was trying, what you said there is exactly what I was trying to say. I try not to get involved in every large case. You asked me if one of my duties, I thought you asked, was to manage large cases. Occasionally, I will manage a task force or a large case. And yes, I oversee the units. We talked about that.
In this particular case, did you play a role in overseeing what happened at SID?
Not all through the case, no.
Well, through part of the case, did you play a role in overseeing what happened at the SID Criminalistics Laboratory?
Along with Mr. Matheson, who was primarily in charge of overseeing the case, and then I worked with him a little bit more.
In fact, Ms. Kessler, didn't you play a larger role in the Simpson case than in other cases because of certain staffing problems with regard to Mr. Matheson being the only deputy you had?
He was the only supervisor in charge of the serology, DNA, and trace unit. So yes, I played a little larger role than I usually do.
A larger role in this case than you usually do, that's correct?
That's correct, yes.
Okay.
And it wasn't just Mr. Matheson, it was just our lack of staffing in several areas.
Isn't it true that the reason was not because of other staffing, but because there was no other assistant laboratory director besides Mr. Matheson? Isn't that the reason?
No, Mr. Matheson wasn't the assistant lab director at that time. He was the supervisor of the serology DNA unit, and Mr. Johnson is the other assistant laboratory director.
On August 1st, 1995, were you asked this question, did you give this answer at a hearing outside the presence of the jury in this courtroom under oath?
Objection,
Yes.
Oh, I'm sorry. You asked this question, did you give this answer? Question. In this particular case, did you play a role in overseeing the processing and handling of the case? Answer. I was attempting to assist in that process because at that time, Mr. Matheson, there was no other assistant laboratory director, so I played a little larger role than I normally would. Did you give that answer to that question just 2 weeks ago?
2 weeks ago?
On August 1st, 1995.
No, I was referring to myself as being,
I'm sorry, Your Honor, I would move to strike. I'm asking if you gave the answer.
She's entitled to answer the question. Answer the question.
what I said that, but I was referring to myself as the only other assistant laboratory director at the time. I don't know I don't remember what that was referring to. Is it out of context?
Next question.
Well, do you acknowledge that you gave that answer to that question just 2 weeks ago in this courtroom?
I possibly did, but I don't know what it was in reference to, but I don't know what time frame it was referring to either. Did you have a time?
Let me show you your testimony.
Thank you. Oh.
Starts here. Goes to here.
Thinking supervisor. I don't know what I was thinking of.
Ms. Kessler, did you give that answer to that question on August 1st at a hearing in this courtroom?
Apparently I did.
Okay. In fact, during the first couple of weeks after September 12th, in fact, during the first couple of weeks after June 12th, 1994, didn't you participate in several meetings concerning this case?
I wouldn't say several, maybe 2 or 3, maybe 4 meetings. Not a lot. I don't recall a lot of meetings.
Well, I didn't ask you if it was a lot. I asked you if you participated in several meetings, Ms. Kessler.
It's vague as well. Sustained.
All right. Ms. Kessler, did you take any notes at the, I'm sorry, you believe you participated in how many meetings during the first 2 weeks?
Just a few
Okay.
that I recall.
All right. In the few meetings that you recall participating in, did you take any notes?
No, I had no reason to.
Well, Ms. Kessler, didn't you say a moment ago that you did play some role in overseeing this case in your role as the assistant laboratory director.
Yes, but I was not any need to take notes. If notes were being taken by the parties involved, if they were necessary, I had no reason to.
Ms. Kessler, as the assistant laboratory director, would you give certain suggestions or directives to other people?
Yes,
And would you agree that one way to know what directives you give to these other people would be to write down what you said so you could look back on it at a later time and see whether or not the person followed your directive?
yes, if I thought at that time that I couldn't remember it myself.
Okay, but you now feel that you didn't need notes because you could remember it?
At that time, I felt I could remember anything that was going on, yes.
All right, well, let's see. When was the first meeting that you participated in connection with this case?
I didn't think that was important, so I wouldn't have written that down anyway, probably.
All right, who was present at the first meeting that you participated in connection with this case?
Again, I wouldn't have thought it was important, so I wouldn't have written it down.
Well, I'm not asking you that. Can you remember who was
No,
there?
I don't even remember when it was.
You don't remember what?
I don't even remember when it was.
Okay, so you don't remember when it was, you don't remember who was there.
No,
Do you remember, the subject matter at the very first meeting you participated in connection with this case?
no, no,
I'm sorry, no?
no.
All right. Isn't it true that as early as 8:30 in the morning on June 13th, you were telephoned, they called you at your home to tell you about this case?
Objection, Your Honor, for the lead.
Sustained.
Did you participate in a meeting on June 15th with Assistant District Attorney Marcia Clark about deciding which evidence should be sent out for testing?
I don't recall the date because I didn't take notes on that. There are notes on that meeting, but I didn't take them. I don't recall the date. We did have a meeting soon after with Marcia
Who
Clark.
took the notes at that meeting?
I believe Greg Matheson.
Did you review Mr. Matheson's notes of that meeting before coming here today?
No, I had no reason to. I didn't know why you were calling me, so.
Who else was present at that meeting on June 15th with Marcia Clark from the District Attorney's Office?
I don't recall.
Was there a discussion at that meeting regarding a decision to send evidence out for DNA RFLP testing?
Oral.
I don't recall if there was that day or not. I know at some point we had a meeting as to what evidence we had and what was going to be tested and who was going to test it.
On the very next day, June 16th, did you participate in another meeting about this case?
I don't recall.
Do you recall being at a meeting with Aaron Riley, Colin Yamauchi, and Dennis Fung, and Greg Matheson about this case on June 16th?
Oral.
I don't recall.
Do you recall participating in a meeting at about that time to discuss the need for security in this case?
Oral.
Security of evidence in general or?
Security of the evidence in this case.
Okay,
Do you
the
recall having that meeting on or about June 16th, 1994?
Objection, assumes fact, not
Oral.
No, I do not recall the meeting, but we have a security policy on evidence in general, which was followed in this case the same as it is in all cases.
I'm not asking you about the policy in general. I'm asking you, ma'am, if you recall participating in a specific meeting to address security issues concerning evidence in this case on or about June 16th, 1994.
Your Honor, assumes fact, not
Oral.
No, I don't recall any meeting regarding that specific issue.
As the director of the criminalistics laboratory at the SID, wouldn't you agree that security of the evidence in this high-profile case would be a concern of yours, the director?
Oral.
I agree that it would be a concern, but it's a concern in every case we have, and we treat all cases regarding evidence the same. Now, if the department classifies it as a confidential case, then the evidence in our property section, whether it be in our property section or somewhere else, is handled differently, but we don't declare it confidential. That's done by the Los Angeles Police Department, not us.
Ms. Kessler, but is it your testimony that there was no specific discussion about security in this case?
No, I didn't say that. Oh, sorry.
Sustained.
Well, what is your recollection as to whether or not there was any meeting to discuss security issues pertaining to this case in particular with other individuals from the SID Criminalistics Laboratory?
Objection, Your Honor. Accident.
Sustained.
Do you recall participating in a meeting? By the way, do you have any notes of a meeting to discuss security in your laboratory?
No, well, I don't personally know, and I don't know if there are any. I didn't review all the notebooks before I came here.
On June 21st of 1994, did you participate in a meeting with Dennis Fung, Greg Matheson, and Colin Yamauchi regarding what additional analysis should be done on the evidence in this particular case?
I don't recall that particular date and time.
Did you take any notes at that meeting?
No, I did not. If I was there. I don't recall the meeting, so I can't answer.
You said a moment ago that one of the reasons you didn't take notes is it was your impression at the time that you could remember what transpired if need be. Do you recall testifying to that a few minutes ago?
Yes, and I said at the time I remembered. At this point in time, I don't remember because at this point in time, it wasn't important. So, once it wasn't important anymore, I don't remember it.
If you don't remember what it is that transpired, how can you determine that it's not important, Ms. Kessler?
Argumentative, counsel. Rephrase the question.
Okay. If you don't remember what transpired at any of these meetings that you were present at, how do you make an assessment as to whether or not what transpired at the meeting was important?
Well, first of all,
Assumes facts aren't evidence. Sustained.
Ms. Kessler, you said you did play some role, a greater role in this case than other cases in overseeing. Is that correct?
in assisting and overseeing. Mr. Matheson, again, was the played the major role, kept the notes, and documented everything.
Would you agree, as part of that role of overseeing or assisting in the overseeing of this case, that maintaining the security of the evidence is certainly an important point?
Yes, I think we talked about this earlier.
And would you agree, Ms. Kessler, that as someone who was assisting in the overseeing of this case in that laboratory, that decisions as to whether or not the evidence should be sent out for DNA testing as opposed to being handled in-house for serological testing is another important question?
Yes, and I never said that we didn't discuss it at some point. I just don't know the date and the time and who was there and exactly when we made those decisions.
Ms. Kessler, didn't you tell this jury a little while ago that not only do you not remember who was there, when it happened, but you don't even remember what was said in substance at those meetings? Isn't that true?
Objection, Your Honor. I guess they testify.
Sustained.
Do you have any recollection at all of the substance of the meeting regarding the security measures that needed to be taken in this particular case?
Sustained.
Your Honor, perhaps this would be a good time to break for the afternoon then?
Proceed.
Okay. Was it your practice, Ms. Kessler, not to take notes in meetings that you participated in where you were involved in assisting to oversee a particular case?
Argumentative, it's ready.
You can answer the question.
It depends on what the substance of the meeting is and how much my role is in the meeting, whether I take notes or not. If I don't give any directives and I just sit back and listen, I don't always take notes.
Ms. Kessler, as you sit here today, do you know whether or not you gave any directives regarding the security that needed to be taken, security measures that needed to be taken regarding the evidence in this case?
Once the case was made confidential, I gave some directives, and those are standard directive policies within the department, so I wouldn't write that down as being specific because it's not to any one particular individual.
Ms. Kessler, what you're saying is you didn't write down then the directives that you gave in this case regarding security. Is that correct, ma'am?
No, other than I notified everyone that it was it's being handled as a confidential case, and confidential cases have a standard way of handling
Your Honor,
the evidence.
I would move to strike. I asked her if she wrote down the directives she gave, not what the directives were.
Answer is stricken, jurors to disregard.
Sorry, I misunderstood what you're asking.
Certainly. Did you write down the directives that you gave regarding security measures to be taken in this case?
No, I just told the people that it was to be handled as a confidential case.
Did you write down any of the decisions that were made regarding what types of analysis should be done in this case?
Those were written on an inventory I did with a couple other individuals on, I believe, June 29th.
Did you write down any of the directives that you gave at a June 21st meeting with Dennis Fung, Greg Matheson, and Colin Yamauchi regarding what types of analyses should be performed?
Sustained.
You said a moment ago that you mentioned directives on a particular date. What was that date, ma'am?
June 29th.
And how do you remember now, on August 14th, 1995, writing down directives on June 29th?
Because I have those in writing.
Well, did you review those documents before you came to court today?
No, but I brought them with me, I believe, or I looked at them before because we talked about them in other meetings.
Are there other notes and documents that you looked at and that you brought with you today to assist you on the witness stand?
Part of my problem, counsel, is I tried to bring like my attendance records and things that you interviewed me about. So those are things I tried to review, and you didn't interview me about any of these things. So I would not have thought to review that.
Did you bring any notes with you to assist you in your testimony today?
Well, if I have my attendance records because you wanted to know where I was on a particular
Kessler,
day,
please.
yes.
I'm just asking you if you brought notes. I'm not even asking you for the particular...
Excuse me. Both of you stop. I'm going to quit today. I want counsel to stay on both sides. Ladies and gentlemen, we're going to take our recess for the afternoon. Please remember all my admonitions to you. Don't discuss the case amongst yourselves, form any opinions about the case. Don't conduct any deliberations till the matter has been submitted to you. Also, don't allow anybody to communicate with you with regard to the case. I'll see counsel in.